Hello everyone. In this video we will discuss more than 500 plus MCQs of Transfer of Property Act. So let's get started from the question number 1. The Transfer of Property Act was enacted in the year 1882. TPA was enacted in the year 1882. Option B is the correct answer. Transfer of Property Act came into force on July 1st, 1882. Option A is the right answer. Question 3. The Transfer of Property Act in 1882 covers movable property, immovable property, none A and B both. Correct answer is D. That is, movable and immovable property both are covered under Transfer of Property Act. Question number 4. Before the commencement of the Transfer of Property Act 1882, the transfer of immovable property in India was governed by principles of English law and equity. Option A is correct. Question number 5. Within the meaning of Section 3 of the Transfer of Property Act, the immovable property does not include only standing timber and grass, only standing timber, house and crops, only standing timber, growing crops or grass, only grass. Here the appropriate answer is C. Does not include only standing timber, growing crops and grass. Question number 6. Immovable property does not include timber. True, false, till it is rooted in the earth. Only the branches of timber does not include an immovable property. Correct answer is true. Question number 7. Which of the following is not the immovable property? A lease of land, growing crops, a right of way, a life interest in the income of immovable property. Here correct answer is option B. Growing crops is not the immovable property. Question number 8. Under Section 3 of the Transfer of Property Act, immovable property includes, options are standing timber, growing crops, grass, none of these. Here the correct answer is none of these. Question number 9. In Transfer of Property Act, immovable property does not include building, land, pond, standing timber. Correct answer is D. Standing timber. Question number 10. Which of the following is not immovable property according to the Transfer of Property Act 1882? Land, benefit to arouse right of land, things attached to earth, standing timber. Here correct answer is option D, that is standing timber. Question number 11. The following is not immovable property. Options are royalty, right to way, right to fishing, right to redemption. Correct answer is royalty, option A. Question number 12. Which of these immovable property as per the provision of Transfer of Property Act 1882? Options are standing timber, grass, fruit trees, growing crops. Here correct answer is fruit trees. Question number 13. Immovable property under the law relating to transfer of property includes growing crops, grass, standing timber, growing trees. Correct answer is option D, that is growing trees. Question number 14. Immovable property does not include, options are grass, growing crops, standing timber, all of the above. Here the correct answer is option D, that is all of the above. That is, grass, growing crops and standing timber are not included in immovable property. Question number 15. Which of the following is not the immovable property? Surface of land, river on surface of land, standing timbers, things attached to earth. Correct answer is option C, standing timbers. Standing timbers is not immovable property. Question number 16. Which of the following is not immovable property under the Transfer of Property Act? A debt secured by the mortgage of an immovable property, a right of worship in a specific temple, a lake, a right to catch and carry fish from a pond. Correct answer is option B, that is right of worship. Question number 17. Standing timber under Transfer of Property Act are immovable properties only so long as not severed from the earth. Immovable properties unless there is a contract to sever the same from the earth. Not immovable property. Immovable properties if the value exceeds ₹100. Here standing timbers under the Transfer of Property Act is not immovable property. Option C is the right answer. Question number 18. Which of the following properties has not been recognized by court as immovable property? Right of way, right to collect rent of immovable property, right of worship, right of fishery. Correct answer is option C, that is right of worship. Question number 19. Which of the following is immovable property? Options are copyright, profits append, royalty, credit. Here correct answer is option B, that is profits append. Question number 20. Which one of the following is not an immovable property? Right to ferry, a decree which gives right to sell the immovable property of husband, life interest of widow in the income of immovable property of her husband, right to receive annual payment from any village. Here correct answer is option B, that is a decree which gives right to sell the immovable property of husband is not an immovable property. Question number 21. Which of the following are immovable property under the Transfer of Property Act? Select the correct answer by using the code given below. The equity of redemption, a hut, mortgage debt, right to recover maintenance allowance charged on immovable property. Here the correct answer is option B. That is, the equity of redemption, hut and mortgage debt are immovable property. Right to recover maintenance allowance charged on immovable property is not immovable property. Question number 22. The test to decide whether something attached to earth has to be regarded as immovable or not depends on the any of the following: the degree or mode of annexation, place of annexation, the object of annexation. Correct answer is option D, both A and C, that is the degree or mode of annexation and the object of annexation. Question number 23. According to section 3 of the Transfer Property Act 1882, instrument means testamentary instrument, non-testamentary instrument, both A and B, none of the above. Correct answer is option B, that is non-testamentary instrument. Question number 24. Attested in relation to an instrument means shall be deemed always to have mean attested by at least 1 witnesses, 2 witnesses, 3 witnesses, 4 witnesses. Correct answer is 2 witnesses. Question number 25. The attestation of document means the attesting witness is aware of the contents of the document. The attesting witness seen the executant sign or affix marks, received from the executant a personal acknowledgement of his signature. Both the attesting witness seen the executant sign or affix mark and received from the executant a personal acknowledgement of his signature. Correct answer is D, that is both the attesting witness seen the executant sign or affix mark and received from the executant a personal acknowledgement of his signature. Question number 26. An instrument of transfer is attested validly where executant has signed the instrument in presence of his family members, a person has signed as a witness to the fact of writing of instrument in his presence, one person who has seen executant signing the instrument put his own signature as witness, instrument is signed by 2 witnesses who have seen executant signing the same and who sign in letter's presence. Question number 26. Correct answer is option D. Question number 27. Which one of the following section of Transfer Property Act defines notice? Section 3 defines notice, that is option B is the right answer. Question number 28. The Privy Council decision in Tilakdhari Lal versus Khedan Lal relates to section 3 of the Transfer Property Act. Option A is the right answer. Question number 29. Under the Transfer Property Act, a person is said to have a notice of a fact when he actually knows the fact, may have knowledge about the fact, could with reasonable care know the fact, is not at all aware of the fact. Correct answer is option A, he actually knows the fact. Question number 30. The Transfer Property Act does not contemplate actual notice, implied notice, notice in transaction, imputed notice. Correct answer is option C, notice in transaction. Question number 31. Which of the following is not a constructive notice? Options are gross negligence regarding to a fact, registration, actual possession, definite knowledge. Not a constructive knowledge, definite knowledge is not a constructive notice. So D is the right answer. Question number 32. Property is a comprehensive term and includes copyright. Reason: Transfer Property Act deals with the all kinds of property including patents. Here correct answer is option C. A is true but R is false. TPA deals only with movable and immovable property, whereas patents and copyright are intellectual properties. So option A is correct, true, and R is false. Therefore C will be the right answer. Question number 33. The chapters and sections of TPA which relate to contract shall be taken as the part of contract and supplemental to option A, the Specific Relief Act, Registration Act, Sales of Goods Act, Partition Act. Correct answer is option B, that is Registration Act. Question number 34. The TPA has no relation with air, water, light, D, all of these. Correct answer is option D, that is all of these. Question number 35. Which one of the following pairs is not correctly matched? Immovable property, section 2. This is not correctly matched, whereas charges, section 100, marshalling by subsequent purchases, section 56, mortgage debt, section 134. Here it has been asked which is the not correctly matched. So option A is not correctly matched, therefore will be the right answer. Question number 36. The amendment of Transfer Property Act 1982 in the year 2002 effective from 31st December 2002. Correct answer is option A, 31st December 2002. Question number 37. Chapter 2nd of the Transfer Property Act shall not be deemed to affect any rule of Mohammedan law, Christian law, Parsi law, none of the above. Correct answer is option A, that is Mohammedan law. Question number 38. The property word is defined in which section of the TPA? Property has not been defined in any section of the Transfer Property Act, therefore option D is the right answer, none of these. Question number 39. Which of the following mode of Transfer Property Act is not covered by TPA? Sale, mortgage, testamentary disposition, exchange. Correct answer is option C, that is testamentary disposition. This mode of transfer is not covered by TPA. Question number 40. Transfer property is not applicable to gifts of movable property, exchange, lease, sale of goods. Correct answer is option D, that is sale of goods. Question number 41. Which of the following do not convey title? Registered exchange deed, registered will, registered gift deed, registered sale deed. Correct answer is option B, that is registered will. Question number 42. Which one of the following cases it was held that partition is not a transfer of property? Here correct answer is option A, that is V. N. Sareen versus Ajit Kumar AIR 1986. Partition is not a transfer of property. It was held in this case. Question number 43. Partition of immovable property is an exchange, a transfer, a gift, none of the above. Correct answer is option D, that is none of the above. Question number 44. In which one of the following cases it was held that surrender by tenant is not transfer? Bachchu versus Hanvansh, Makhanlal Sahu versus N.N. Adhikari, Sharda Devi versus Chandwala, none of these. Correct answer is option B, that is Makhanlal Sahu versus N.N. Adhikari. In this case, it was held that surrender by tenant is not transfer. Question number 45. To which of the following sections, section 5 to 37 of the TPA apply? Options are transfer of movable property, transfer of immovable property, transfer of property whether movable or immovable, a specific transfer, and not to general principles of transfer of property. Here correct answer is option C, that is transfer of property whether movable or immovable. Section 5 to 37 apply. Question number 46. Which one of the following section of Transfer of Property Act defines transfer of property? Correct answer is section 5. Question number 47. Transfer of Property Act governs transfer between the living persons, and transfers by the order of a court, between living persons and transfer by operation of law. D, all of the above. Correct answer is option A. Transfer of Property Act governs transfers between living persons only. Question number 48. Under the Transfer of Property Act, a living person connotes human being only, limited company only, partnership firm only, all of these. Correct answer is option D, that is all of these. Question number 49. The Transfer of Property Act applies to transfer of property made by act of parties, by operation of law, by a decree or order of a court of competent jurisdiction, in execution of a decree or order of a court of competent jurisdiction. Correct answer is option A, that is made by act of parties. Question number 50. Which one of the following is not transferred by an act of parties under Transfer of Property Act? Options are succession, sale, mortgage, gift. Correct answer is option A. Succession is not a transfer by an act of parties under TPA. Question number 51. Under Section 5 of Transfer Property Act, living persons includes individual human being only, company or association or body of individuals, none of the above. Correct answer is option C, that is company or association or body of individuals. Question number 52. Transfer of property means transfer between living person, transfer between living person and trust, transfer between legal person, includes all. Here correct answer is option D, that is includes all. Question number 53. In respect of the transfer of property under Transfer of Property Act, which of the following statement is not true? Transfer can be done immediately or in future. Transfer of property can be done to one or more living persons. One cannot transfer property to oneself, none of them. Here correct answer is option C. One cannot transfer property to oneself. This is not true. One can transfer property to oneself also. Therefore, according to the question which has been asked, correct answer is option C. Question number 54. Which of the following is not a transfer according to TPA? Sale, gift, exchange, abandonment of a claim to property. Here option D is the right answer. This is not a transfer according to the TPA. Question number 55. Transfer of property does not include sale, lease, will, gift. Correct answer is option C, will. Will is not included in TPA. Will is included in Indian Succession Act. Question number 56. Which is not covered by the term transfer of property? Gift, exchange, family settlement, lease. Correct answer is option C, that is family settlement. Under the Transfer of Property Act, the expression transfer of property includes partition, surrender, family arrangement, none of these. Correct answer is option D, none of these. 58. Which of the following is included in term living person under section 5 of the TPA? A company, an association, body of individuals, all of these. Correct answer is option D, all of these. Question number 59. The term transfer under the Transfer of Property Act refers to Partly or whole transfer, absolute or conditional transfer, contingent transfer, both A and B are correct. Correct answer is option D, that is both A and B are correct. Partly or whole transfer, absolute or conditional transfer. Question number 60. Which one of the following statement is not correct in the context of transfer of property? It means an act which a living person conveys property. He conveys property in present or in future. He conveys property to one or more living persons. He cannot transfer property to himself and one or more living persons. Not correct. D is not correct. One can transfer property to himself. Question number 61. Section 6 of the Transfer Property Act is related to transfer of property, person competent to transfer, what may be transferred. Correct answer is option C, that is what may be transferred. Section 6 of TPA is related to this. Question number 62. Which one of the following sections of the Transfer Property Act provides that mere right to sue cannot be transferred? Correct answer is option B, that is section 6. Question number 63. Chance of an heir apparent succeeding to an estate cannot be transferred. Which provision of the Transfer Property Act state this? Section 10, Section 6, Section 16, Section 41. Correct answer is Section 6. Question number 64. How many exceptions are mentioned under the Section 6 of Transfer Property Act? There are total 10 exceptions mentioned in the Transfer Property Act. Therefore, option C will be the correct answer. Question number 65. The expression spec successions means no chance of succession, mere chance or hope of succession, absolute succession, none of the above. Correct answer is option B, that is mere chance or hope of succession. Question number 66. Which interest is not transferable? Vested interest, contingent interest, mere spec succession, interest of the lessee. Here the correct answer is option C, that is mere spec succession is not transferable. Question number 67. Which one of the following is correct? An easement can be transferred apart from the dominant heritage. A mere right to sue cannot be transferred. A right to future maintenance can be transferred. The salary of a public officer after it has become payable can be transferred. Correct answer is option B, that is a mere right to sue cannot be transferred. Question number 68. Which of these cannot be lawfully transferred as per the TPA? Salary of public officer, machinery attached to land, property yielding income, paddy field. Here correct answer is option A, that is salary of public officer. Question number 69. As per section 6 of the Transfer Property Act 1882, an easement dash be transferred apart from the dominant heritage. Here the correct answer is option B, that is an easement cannot be transferred apart from the dominant heritage. Question number 70. Which property cannot be transferred? A public office, a mere chance to succeed, a mere right of re-entry, all of the above. Correct answer is option D. All the properties which are mentioned here cannot be transferred. Question number 71. Which of the following is a legal transfer under the provisions of TPA? A right to sue, a chance of an heir apparent to succeed, an easement apart from the dominant heritage, second mortgage of the property. Here the correct answer is option D, that is second mortgage of the property. Question number 72. Under the Transfer Property Act, what property may be transferred? A mere right to sue, public office, the chance of an heir apparent succeeding to an estate, any property which is not barred by the law. Option D is the correct answer. Question number 73. Which cannot be transferred? Mere right to sue on the basis of agreement to sell, right to receive areas of rent, right to recover disretail amount, right to receive provident funds by will. Here correct answer is option A, that is mere right to sue on the basis of agreement to sell cannot be transferred. Question number 74. Which of the following properties cannot be transferred? Share in copyright, interest in mortgage property, right to future maintenance, immovable property. Correct answer is option C. Right to future maintenance cannot be transferred. Question number 75. Point out the correct answer. Under the Transfer Property Act 1882, the salary of the public officer can be transferred. The salary of a public officer cannot be transferred. No provisions regarding the transfer of salary of a public officer is found in the Act. None of the above. Here correct answer is option B, that is the salary of public officer cannot be transferred. Question number 76. Which one of the following properties may be transferred? Mere easement, a right to future maintenance, immovable property, a right to sue. Correct answer is option C, that is immovable property. Question number 77. A right of future maintenance in whatsoever manner arising, secured or determined can be transferred, cannot be transferred, can be sold, can be vested. Correct answer is option B, that is cannot be transferred. Question number 78. What can be transferred under TPA? An easement along with the dominant heritage, political pension, space succession, stipends allowed on the civil pensioners of the government. Correct answer is option A, that is an easement along with the dominant heritage can be transferred. Question number 79. What kind of property is transferable? Right of re-entry, public office, any kind of property if not prohibited by law, pension. Correct answer is option C. That is, any kind of property if not prohibited by law can be transferred in Transfer of Property Act. Question number 80. Section 6 of the TPA provides the property of any kind may be transferred except the following: a mere right to sue, a public officer, or salary of a public officer, the chance of an heir apparent succeeding to an estate, an easement apart from the dominant heritage. Here none of the above can be transferred. So option D is the right answer. Question number 81. Which one of the following section of TPA provides for the competency to transfer any immovable property? Options are Section 17, Section 6, Section 10, Section 7. Correct answer is option D, that is Section 7. Question number 82. Persons competent to transfer property have been defined under which of the following sections of TPA? Correct answer is option B, that is Section 7. Question number 83. Which of the following is not an essential element for a valid transfer of property? Competent transfer, transferable property. Transferee may not be competent to take the transfer. Object of transfer must be lawful. Correct answer is option C, that is transferee may be competent to take the transfer. Question number 84. In the light of the provisions of the TPA, minor can transfer a property, cannot transfer property, can accept transfer of property in his favor, both B and C. Correct answer is option D, that is both B and C. That is, cannot transfer a property and can accept transfer property in his, and option C is the right answer. Can accept property in his favor but he cannot transfer a property. Question number 85. Which one of the following section of Transfer Property Act relates to oral transfer? Options are Section 5, Section 7, Section 8, Section 9. Correct answer is option D, that is Section 9. Section 9 relates to oral transfer. Question number 86. Which one of the following section of TPA says that a transfer of property may be made without writing in every case in which a writing is not expressly required by law? Here correct answer is option D, that is Section 9, which talks about the oral transfer of property. Question number 87. Section 9 of the Transfer Property Act provides that transfer can only be done through a transfer deed. Transfer can be oral without writing also. Transfer can only be done through a registered deed. Transfer can be done only by writing. Here correct answer is option B, that is transfer can be oral or without writing also. Question number 88. Under TPA, where a writing is not expressly required by law, a transfer property may be made without writing in every case. A transfer property is subject to only writing. No provision of oral transfer is made. None of the above. Correct answer is option A, that is a transfer of property may be made without writing in every case. Question number 89. When writing is not expressly required by law, a transfer of property may be made orally. False. Transfer can only be made by writing. With the consent of the parties, oral transfer can be done. True. Here correct answer is option D, that is true. Question number 90. Condition restraining alienation of property is given under. Correct answer is option B, that is Section 10 of TPA talks about the condition restraining alienation of property. Question number 91. Condition restraining alienation under Section 10 of TPA makes the transfer invalid, makes the condition invalid but transfer remains valid, makes the condition as well as transfer both invalid. None of the above. Here correct answer is option B, that is makes the condition invalid but transfer remains valid. Question number 92. A sells his house B with a condition that B cannot transfer his house to anyone except C. The sale is valid but condition is void. Question number 93. Which one of the following is invalid as per Section 10 of the TPA? A condition not to sell outside the family, a condition not to sell to a person of different community, a condition not to sell during the lifetime of the transferee, a condition in the lease that lessee shall not sublet his interest to anyone. Here correct answer is option C, that is a condition not to sell during the lifetime of the transferee is invalid as per Section 10 of Transfer Property Act. Question number 94. Absolute restriction on the transfer of property is void under Section 10 of TPA. Question number 95. A sells a house to B directing B that he cannot reside in it but can only use it as a godown or shop. The condition is valid, void, irregular, voidable. Correct answer is void. Condition is void. Question number 96. Whether a gift with a condition not to transfer the gifted property is legal? Yes, no, yes only with the permission of the court, none of the above. Here 96 correct answer is no. A gift with a condition cannot be gifted. Question number 97. Section 11 of the Transfer Property Act will be applicable only when the interest is transferred in the property is limited, absolute, both A and B, none of the above. Correct answer is option B, that is absolute. Section 11 of the TPA will be applicable only when the interest transferred in the property is absolute. Question number 98. A leading case on the restriction repugnant to interest created in. Here correct answer is Tull versus Moxhay. Question number 99. If the transfer property is made with conditions, the condition is void and the transfer is invalid. Where the transfer is made with void condition, where transfer is made with the condition that restraining absolute future transfer of such property, where transfer is made absolute with the condition restraining enjoyment of such property. Correct answer is option D, that is both B and C. Question number 100. If a property is transferred with the condition that an interest created therein for the benefit of the transferee shall cease on his becoming insolvent, such a condition is void under which of the following sections of the TPA? Correct answer is section 12 of TPA. Section 12 of the Transfer of Property Act 1882 is not applicable. Option A, where the transfer is by way of sale, where the transfer is by way of gift, where the transfer is by way of exchange, where the transfer is by way of lease. Here at option D, section 12 will not be applicable. Other options, sale, gift or exchange, section 12 will be applicable. Question number 102. Which one of the following sections of Transfer of Property Act 1882 is concerned with the transfer to the benefit to unborn child? Options are section 13, section 14, section 15, section 16. Correct answer is section 13. Question number 103. Whether a transfer can be made in favor of an unborn person? Options are yes, by machinery of trust, yes, guardian has got to be appointed first, none of the above. Correct answer is option A, yes, by the machinery of trust. Question number 104. Transfer of property for the benefit of an unborn person can be made by creation of a prior interest in favor of a living person for any period, vesting the right directly to the unborn, creating of a prior interest in favor of a living person till the existence of unborn person, either to the unborn or to a living person. Here correct answer is option C, that is creation of a prior interest in favor of a living person till the existence of unborn person. Question number 105. For creating an interest in favor of an unborn person, which of the following is essential? Creation of a prior life interest in favor of a living person's. Unborn person must be born before the termination of the last prior life interest. Absolute interest is to be given to unborn person. All of the above. Here correct answer is option T, that is all of the above. Question number 106. In which section rule against perpetuity was propounded? Options are section 12, section 13, section 14, section 15. Correct answer is section 14. In section 14, rule against perpetuity is propounded. Question number 107. Rule against perpetuity given under the Transfer Property Act 1882 does not affect any rule of Hindu law, Mohammedan law, Christian law, none of the above. Correct answer is option B, that is Mohammedan law. Question number 108. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of such transfer. These provisions come under rules against retrospective transfer only, rules against perpetuity, rules against prospective transfer, none of these. Correct answer is option B, that is rule against perpetuity. Question number 109. Rule against perpetuity is a rule against transfer of property, rule favoring transfer of property, rule fixing the maximum period of time for which the vesting property can be postponed. Correct answer is option C, that is rule fixing the maximum period of time for which vesting of property can be postponed. Question number 110. Rule against perpetuity is applicable to movable property, immovable property, both movable and immovable properties, de-transfer for the benefit of public. Here the correct answer is option C, that is both movable and immovable properties. Question number 111. Rule against perpetuity prescribes that every transfer of immovable property must be by registered document. Every transfer of immovable property must be in writing. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living on the date of such transfer. None of the above. Here correct answer is option C. Question number 112. The rule against perpetuity do not apply to which of the following? Movable properties, charities, immovable properties, all of the above. Correct answer is option B, that is charities. Question number 113. Which one of the following is an exception to the rule against perpetuity? Permanent transfer for gift, personal covenants, preemption, all of the above. Correct answer is option D, that is all of the above. Permanent transfer of gifts, personal covenants, preemption, all are then exception of rule against perpetuity. Question number 140. Rule against perpetuity is not applicable to a case where property is transferred for the benefit of the public, interest in property is created generation after generation, transfer property purport to be effective beyond minority of ultimate transferee who is not in the existence, interest are date of transfer, contingent interests are created by transfer. Here correct answer is option A, that is property is transferred for the benefit of the public. Here rule against perpetuity will not be applicable. Question number 115. With the reference to the Transfer of Property Act, Ram Baran versus Ram Mohit AIR 1967 is a case for nemo dat quod non habet, rule against perpetuity, elections, easements. Correct answer is option B, that is rule against perpetuity. Question number 116. Section 14 of Transfer of Property Act provides for the rule against perpetuity. Reason: this rule is based on public policy. Here both A and R are true and R is the correct explanation of A. So option A will be the right answer. Question number 117. A transfers property to B for life and thereafter to his unborn son for life. In this case of transfer, the property to the unborn son is, options are valid, illegal, voidable, void. Correct answer is option D, that is void. Question number 118. Rule against double possibilities was recognized in which of the following cases? Option are Girejesh Datta versus Datadeen, Whitby versus Michel, Ardisar versus Jaddaboy, Sofer versus Administrative General of Bengal. Here correct answer is option B, that is Whitby versus Michel. The rule against double possibilities was recognized. Question number 119. Under TPA, which one of the following is correctly matched? Condition restraining alienation section 9, rule against perpetuity section 14, conditional transfer section 25, option D, none of the above. Correct answer is option B, that is rule against perpetuity is given under section 14 of TPA. Question number 120. Which one of the following section of TPA deals with the direction for accumulation? Options are section 14, 17, 19 or 18. Here correct answer is option B, that is section 17. Question number 121. The principle of section 17 of the Transfer of Property Act based on which one of the following cases? Option are Girejesh versus Datadeen, Chamar Sahu versus Sona Quer, Teluson versus Woodford, none of these. Here correct answer is option C, that is Teluson versus Woodford. Question number 122. Under which section of Transfer Property Act there is a restriction for accumulation of property beyond a certain period? Options are section 17, section 14, section 20, section 25. Correct answer is option A, that is section 17. Question number 123. Provision of longer period in the matter of accumulation of property under section 17 of Transfer Property Act amounts to 18 years, 20 years, 22 years, 25 years. Correct answer is option A, that is 18 years. Question number 124. Which section creates exception of the restriction of section 14, 16, 17 of TPA? Options are section 15, section 19, section 17A, section 18. Correct answer is section 18, that is option D. Question number 125. According to section 18 of TPA, the provisions of some sections shall not apply in the case of transfer of property for the benefit of the public in the advancement of religion, knowledge, commerce, health, safety or any other object beneficial to mankind. These sections are, here correct answer is option B, that is section 14, section 16 and section 17. Question number 126. In case of transfer property for the benefit of the public, which of the following restrictions shall not apply? Rule against perpetuity, transfer to take effect on failure of prior interest, direction of accumulation. Here correct answer is option D, that is all of the above. Question number 127. A vested interest is not defeated by the death of a transferee before he obtains possession is provided in which of the following section of TPA? Options are section 18, section 19, section 20, section 21. Correct answer is option B, that is section 19. Question number 128. A transfer the property to B in trust for C and directs B to give possession of the property to C when he attains the age of 25. C's interest in the property is vested. Option B is the correct answer. Question number 129. A by settlement deed transfers property to P for life, then to S. S dies before P dies. On the death of P, the heir of S claims the property. Is the claim valid? Options are valid since S interest is heritable, invalid since S interest is contingent, invalid since settlement deed is vague, none of the above. Here option A is the right answer, valid because S interest is heritable. Question number 130. Where on a transfer of property an interest therein is created in favor of a person without specifying the time when it is to take effect, or in the terms specifying that it is to take effect forthwith or on the happening of an event which must happen, such interest is contingent interest, vested interest, perfect interest, agreement to sell. Correct answer is option B, that is vested interest. Question number 131. A man gives his property to a temple subject to the condition on the death of his wife. What is created by the transaction? Spec successions, contingent interest, vested interest, none of the above. Correct answer is option C, that is vested interest. Question number 132. Under the TPA, when can an unborn person acquire vested interest on a transfer for his benefit? Options are upon his birth, upon completing the majority age, upon his marriage, none of the above. Correct answer is option A, that is upon his birth. Question number 133. Section 21 of the Transfer Property Act 1882 contains provisions relating to contingent interest. A is the right answer. Question number 134. Contingent interest in the property becomes a vested interest on the happening of an uncertain event. When the happening of event becomes possible, impossible, probable to happen, all of the above. Here correct answer is option B, that is impossible. Question number 135. Where on a transfer of property an interest therein is created in favor of a person to take effect only on the happening of a specified uncertain event, the transfer is called as contingent transfer. Question number 136. Which of the following is not correctly matched? Options are rule against perpetuity section 14, conditional transfer section 24, vested interest section 19, contingent interest section 21. Here conditional transfer, that is option B, is not correctly matched. Other options are correctly matched. Question number 137. Section 25 of the Transfer Property Act deals with condition precedent. Section 25 of the Transfer Property Act deals with condition precedent. Question 138. A lets the farm to B on a condition that he shall walk 100 miles in an hour. The lease is void under section 23, under section 24, under section 25, none of the above. Here correct answer is option C, that is under section 25 of TPA. Question number 139. Which of the following is the example of valid conditional transfer? Options are A let farm to B on condition that he shall walk 100 miles in an hour. A transfer rupees 500 to B on condition that she shall murder C. A transfer rupees 1500 to his niece if she will desert her husband. And option D, A transfer rupees 500 A to B on a condition that he shall execute a certain lease within the 3 months after A's death. Here correct answer is option D, that is A transfer rupees 500 A to B on a condition that he shall execute a certain lease within 3 months after A's death. Question number 140. Which of the following would be a valid transfer under the TPA? Options are A lets a farm to B on a condition that he shall walk 100 miles in an hour. A gives rupees 500 to B on condition that he shall marry A daughter C. A at the date of the transfer, C was dead. Option C, A transfer rupees 500 to B on a condition that she shall murder C. Option D, A transfer rupees 5000 to B on a condition that he shall marry with the consent of C, D and E. E dies, B marries with the consent of C and D. This will be the valid transfer. Option D is the right answer. Question number 141. A gives rupees 500 to B on a condition that B shall marries A daughter G. On the date of the transfer, G was dead. The transfer is void under which section of the TPA? Here correct answer is option A, that is section 25 of TPA. Question number 142. Which section embodies doctrine of Cyprus? Options are section 25, section 26, section 27, section 28. Correct answer is option B, that is section 26. Question number 143. A transfer rupees 5000 to his niece B. If she will desert her husband, the transfer is void. Question number 144. In case of a transfer depending on a condition precedent, the transfer take place when the condition is partially fulfilled, strictly fulfilled, substantially fulfilled, wholly fulfilled. Here correct answer is option C, that is substantially fulfilled. Question number 145. Under the TPA 1882, A transfer rupees 5,000 to B on a condition that he shall marry with the consent of C, D and E. E dies, B marries with the consent of C and D. Here transfer is valid. Option A is the right answer. Question number 146. X transfer rupees 5,000 to Y on a condition that he shall marry with the consent of A, B, C. Y married without the consent of A, B and C but obtains their consent after the marriage. Y has fulfilled the condition, not fulfilled the condition, substantially complied with, none of the above. Here correct answer is option B, that is not fulfilled the condition. Question number 147. A transfer rupees 5,000 to B on a condition that he shall marry with the consent of C, D and E. B marries without the consent of C, D and E. B obtains their consent after the marriage. Has B fulfilled the condition? No, B has not fulfilled the condition. So correct answer will be option B, no. Question number 148. Which one of the following statement is not correct? Options are: A transfers a farm to B for her life, and if she does not desert her husband to C, B is entitled to the farm during her life as if no condition had been insisted. Option B. A transfer rupees 50,000 to B on a condition that he shall marry with the consent of C, D and E. B marries without the consent of C, D and E but obtains their consent after marriage. The condition shall be deemed to be fulfilled as it has been substantially complied with. This is not the correct statement, therefore will be the right answer. Question number 149. Provisions based on the doctrine of acceleration under TPA is, correct answer is section 27. Doctrine of acceleration, section 27 TPA. Question number 150. A transfer rupees 5,000 to B on a condition that he shall execute a certain lease within 3 months after A's death, and if he should neglect to do so to C, B dies in A's lifetime. Which section of the Transfer Property Act shall apply in deciding the legal right of C? Options are section 29, section 26, section 25, section 27. Correct answer is option D, that is section 27 TPA. Question number 151. A transfer a farm to B for his life with a proviso that in case B cuts down a certain wood, the transfer shall cease to have any effect. B cuts down the wood. What will be the effect of his life interest of farm? Option A, loses. Option B, secures. Option C, conditional loss. Option D, conditional secures. Correct answer is option A, that is loses. Question number 152. Which one of the following is not correctly matched? Options are contingent interest, section 21, direction for accumulation, section 17, fulfillment of conditions subsequent, section 30, priority of rights created by transfer, section 48. Here it has been asked which of the following is not correctly matched. Option C is not correctly matched. Question number 153. Which of the following deals with the doctrine of election? Correct answer is section 35. Section 35 deals with the doctrine of election. Question number 154. Which of the following provisions of TPA provides that a person taking the benefit of instrument must also bear the burden? Options are section 35, section 34, section 33, section 32. Correct answer is section 35. Question number 155. A man is not allowed to approbate and reprobate at the same time. This rule provides basis for which of the following? Doctrine of feeding of grant by estoppel, doctrine of part performance, doctrine of election, rule of redeem of foreclosure down. Here correct answer is option C, that is doctrine of election. Question number 156. Doctrine of election comes under the chapter of TPA. 7th, 2nd, 4th, 5th. Correct answer is option B, that is 2nd. Section 35 of the TPA is applicable to movable property, immovable property, every kind of property, all of the above. Here correct answer is option D, that is all of the above. Question number 158. The foundation of the doctrine of election under the TPA is that a person taking the benefit of an instrument must bear the burden, must not bear the burden. Burden is not the subject of election, none of the above. Here correct answer is option A, must bear the burden. Question number 159. The doctrine of election is applicable to Hindus, Muslims, Christians, all of the above. Correct answer is option D, that is all of the above. Question number 160. If the owner of the property elects to dissent from the transfer under section 35 of TPA, the disappointed transferee is entitled to be compensated when the transfer is gratuitous and the transferor dies before the election. The transfer is gratuitous and the transferor becomes incapable of making fresh transfer before election. The transfer is for consideration. All of the above. Here correct answer is option D, that is all of the above. Question number 161. Muhammad Afzal versus Ghulam Qasim 1903 is a leading case on which of the following? Rule against perpetuity, equity of redemption, doctrine of election, doctrine of holding over. Correct answer is option C, that is doctrine of election. Muhammad Afzal versus Ghulam Qasim is a leading case related to doctrine of election. Question number 162. The farm of Sultanpur is the property of C, worth rupees 8,000. A, by an instrument of gift, professed to transfer it to B, giving by the same instrument rupees 1 lakh to C. A dies before the election. B shall be entitled to get rupees 20,000 from C, entitled to get rupees 80,000 from C, entitled to get rupees 80,000 from A's representatives, not to be entitled to get any amount from anyone. Here correct answer is option C, entitled to get rupees 80,000 from A's representative. Question number 163. The provisions regarding apportionment by time is given under which of the following sections of TPA? Options are section 35, section 36, section 37, section 38. Here correct answer is option B, that is section 36. Section 36 of the TPA is related to the doctrine of election, doctrine of surplus, doctrine of acceleration, doctrine of apportionment. Correct answer is option D, that is doctrine of apportionment. Question number 165. Section 37 of the TPA on right to proceeds of revenue compensation on acquisition is based on doctrine of election, doctrine of substituted security, doctrine of marshalling, doctrine of contribution. Correct answer is option D, that is doctrine of contribution. Question number 166. Transfer Property Act. The right of a third person for maintenance cannot be enforced under section 39 against transferee who is gratuitous for consideration without notice of the right, gratuitous transferee without notice for consideration but with the notice of the right. Correct answer is option B, for consideration without notice of right. Question number 167. A has let house at a rent of rupees 100 payable on the last date of each month. A sells house to B on the 15th June. On 30th June, what will be the apportionment? Options are A will get rupees 100, B will get rupees 100, rupees 50 to A and rupees 50 to B. The tenant will be exempted from the payment of rent in that month. Here correct answer is option C, that is rupees 50 to A and rupees 50 to B. Question number 168. The transfer by ostensible owner is provided in which section of TPA? Options are section 38, section 39, section 40, section 41. Here correct answer is option D, that is section 41. Question number 169. Which one of the following is not correctly matched? Options are oral transfer, section 9 of TPA, rule against perpetuity, section 14 of TPA, doctrine of election, section 35 of TPA, transfer by sustainable owner, section 40 of TPA. Correct answer is option D, that is transfer by ostensible owner is not correctly matched. Question number 170. The transfer of property by ostensible owner for consideration shall be void, shall be valid, shall not be voidable provided that transferee acted in good faith, shall be voidable. Correct answer is option C. Transfer property by ostensible owner shall not be voidable provided that transferee acted in good faith. Question number 171. The case of Jaya Dayal Poddar versus BB Hazara is related to Options are doctrine of election, doctrine of part performance, transfer by unauthorized person, ostensible owner. Here correct answer is option D, transfer by ostensible owner. Question number 172. Section 41 of the Transfer Property Act 1882 is the statutory application of the law of waiver, estoppel, res judicata, res sub judice. Correct answer is option B, that is estoppel. Question number 173. In Ram Kumar Kundu versus McQueen 1872 is related to. Options are lispendence, ostensible owner, part performance, mortgage. Correct answer is option B, ostensible owner. Question number 174. Section 41 of the TPA 1882 applies to voluntary transfer and has no applicable to court sale, contingent sale, perpetuity sale, priceless sale. Correct answer is option A, that is court sale. Question number 175. Principle laid down by the Privy Council as to the constructive notice of the real title as provided in section 41 was reaffirmed by the Supreme Court in. Correct answer is option C, that is Jumma Masjid Markara versus Kodi Manindra Devaiya. Question number 176. Section 41 of the Transfer Property Act 1882 is the statutory application of the law of estoppel. The statement is true, false, partly true, none of the above. Correct answer is option A, that is true. Question number 177. Which of the following case involving section 41 of the Transfer Property Act? Options are Suraj Ratan Tirani versus Azmabad Tea Company, Bellamy versus Sabine, Prabodh Kumar versus Jantamara Tea Company, Tulk versus Moxie. Here correct answer is option A, that is Suraj Ratan Tirani versus Azmabad Tea Company. Question number 178. Rule of feeding the estoppel is contained in section 41 of TPA, section 42, section 43, none of the above. Here correct answer is option C, that is section 43 of the Transfer Property Act. Rule of feeding estoppel is contained in. Question number 179. Doctrine which requires that the transferor must deliver the subsequently acquired property to the transferee who acted upon his false representation and did harm to himself by paying money for what he could not get is called rule against unjust enrichment, implied consent, feeding the grant by estoppel, doctrine of substantial compliance. Correct answer is option C, that is feeding the grant by estoppel. Question number 180. Section 43 of the TPA, which deals with the transfer by unauthorized person who subsequently acquires the interest in immovable property transferred, underlies the doctrine of. Options are actionable claim, estoppel by deed, estoppel by election, right of preemption. Correct answer is option B, that is estoppel by deed. Question number 181. Where a person transfers property representing that he has a present interest therein, whereas he has in fact only a space succession, the transfer is entitled to the benefit of section 43 if he has taken the transfer on the faith of that representation and for consideration as section 43 and section 6 clause A operate on different fields. The principle was laid down in Rajesh Kanta Roy versus Shanti Devi, Chunman Jha versus Ibadat Ali, Jumma Masjid Markara versus Kodi Mandindra Devaiya, Ram Baran Prasad versus Ram Rohit Hazara. Here the correct answer is option C, Jumma Masjid Markara versus Kodi Mandira Devaiya. Question number 182. Section 43 of the TPA enables a transferee to whom transferor has made a fraudulent or erroneous representation to lay hold at his option of any interest which the transferor may subsequently acquire in property, provided it does not adversely affect right of any subsequent purchaser for value without notice. Option A is the correct answer. Question number 183. Which one of the following is not an essential condition for section 43 of TPA? Options are the representation must be necessarily be fraudulent, the transferor makes a representation that he is competent to transfer, transfer is of immovable property, transfer is for consideration. Here in this question it has been asked which of the following is not an essential condition of section 43. So option A is not the essential condition of section 43, therefore will be the correct answer. Question number 184. A Hindu who has separated from his father B sells to C three fields X, Y and Z, representing that A is authorized to transfer these fields. Z does not belong to A, but on B's death A obtains Z. C did not rescind the contract. Contract become infructuous. C may acquire A to deliver Z to him. Contract is void. Contract is unenforceable. Here correct answer is option B, that is C may require A to deliver Z to him. Question number 185. X sells to Y property belonging to Z. Subsequently Z dies and the property devolves on X. By which doctrine the said sale is valid? Options are doctrine of estoppel, doctrine of promissory estoppel, doctrine of feeding the grant of estoppel, doctrine of estoppel by conduct. Correct answer is option C, that is doctrine of feeding the grant of estoppel. Question number 186. The principle of estoppel enunciated in section 115 of Indian Evidence Act find its expression in these sections of TPA. Options are section 35 and section 53A, section 41 and 43, section 35 and section 43, section 35, 43 and section 60. Correct answer is option B, that is section 41 and section 43. Question number 187. Section 44 of the TPA deals with transfer by two co-owners, transfer by one co-owner, transfer by three co-owners, transfer by all co-owners. Here correct answer is option B, that is transfer by co-owners. Question number 188. A co-owner of immovable property under TPA may make a valid transfer of property, only can give possession, only can give right to use for a short period, cannot make the transfer of that property. Here correct answer is option A, that is valid transfer of property. Question number 189. Where immovable property is transferred for consideration by persons living distinct interests therein, but their interests in the property are of equal value, the transferor are entitled to get equal share in the consideration, entitled to get unequal share in the consideration, entitled to get equal share subject to the further transfers in future, none of the above. Here correct answer is option A, that is entitled to get equal share in the consideration. Question number 190. The doctrine nemo dat quod non habet under the TPA Act is applied to? Options are Section 41, Section 42, Section 43 and Section 44. This is the correct answer. Option A is the right answer. Question number 191. Nemo dat quod non habet, no man can confer a better title than that which he himself has, is an established principle of rule of transfer of property, rule of law of torts, rule of law of crimes, rule of contract. Correct answer is option A, that is rule of transfer of property. Question number 192. Under section 49 of TPA, the transferee is entitled to the benefits of the insurance covered against the loss of damage by fire, encroachment, natural calamity, none of the above. Correct answer is option A, that is fire. Question number 193. Within the meaning of section 51 of the Transfer Property Act, the transferee is not entitled to value of improvements, is entitled to value of improvements, has conditional entitlement to value of improvements, none of these. Correct answer is option B, that is entitled to value of improvements. Question number 194. He who seeks equity must do equity. The juristic basis of which of the following section of TPA? Correct answer is section 51. Question number 195. Doctrine of lis pendens is dealt under section dash of TPA. Correct answer is section 52. Doctrine of lis pendens. Question number 196. The literary meaning of lis pendens is a suit under consideration of any court of law. A is the right answer. Question number 197. Under section 52 of TPA, the transferee will be bound by the result of the suit if he has knowledge of the litigation, if he had no knowledge of the litigation, even made bona fide inquiry, if he has paid adequate consideration for the purchase, whether the transferee has knowledge or not as to the litigation. Correct answer is option D, whether the transferee has knowledge or not as to the litigation. Question number 198. Section 52 of TPA imposes a prohibition on transfer or otherwise dealing of any property during the pendency of a suit, provided the conditions laid down in sections are satisfied. The statement is false, true, partly true, none of the above. Correct answer is option B, that is true. Question number 199. Rule of lis pendens is applicable to suits for specific performance of contract to transfer the immovable property. The statement is false, true, partly true, depends on the facts of each case. Here correct answer is option B, that is true. Question number 200. 𝐯𝐴𝐿 versus 𝐶𝐲 case is related with which doctrine? Options are doctrine of perpetuity, doctrine of election, lis pendens, part performance. Correct answer is lis pendens. Question number 201. Which of the following is not an essential condition for the application of rule of lis pendens under section 52 of TPA? Options are pendency of a suit or proceeding, pendency in a competent court, suit must be collusive, alienation must affect the right of other party. Correct answer is option C, that is suit must be collusive is not an essential condition. Question number 202. The rule of lis pendens embodied in section 52 of the TPA pertains to bona fide purchase, public policy, auction sale, none of the above. Correct answer is option B, that is public policy. Question number 203. The doctrine of lis pendens is explained in famous case of, correct answer is 𝐷𝐿𝐴 versus 𝐶𝐲. This is the leading case in which the lis pendens has been explained. Question number 204. The object of lis pendens is to only maintaining the status quo, only restraining further litigation, only restraining creation of a new fact during the legislation, all of these. Here correct answer is all of these. Question number 205. The rule of lis pendens applies when the suit in which right to immovable property is fraudulent and is directly in question, is pending between two persons and one of them sells property, is pending in a court which does not have jurisdiction. Correct answer is option C, that is pending between two persons and one of them sells property. Question number 206. For applicability of doctrine of lis pendens, the property must be movable, immovable, both A and B, none of these. Correct answer is option B, that is immovable. Question number 207. During the pendency of a suit for recovery of an immovable property, if the defendant transfers the property, the decree can be executed against the transferee. The decree cannot be executed against the transferee. The plaintiff should file a fresh suit against the transferee. The plaintiff has no remedy. Correct answer is option A, that is the decree can be executed against the transferee. Question number 208. The doctrine of lis pendens applies where suit is collusive, where the transfer is made during the pendency of suit, where the title to movable property is an issue, where the property is situated beyond the territorial jurisdiction of the court. Correct answer is option B, where the transfer is made during the pendency of suit. Question number 209. Doctrine of lis pendens embodied in section 52 of TPA invalidate the transfer of immovable property during pending of the suit. It only enacts that the purchaser pendent light suit is bound by the result of litigation. It barred the transfer of property during pending of the suit. It protects the right of collusive transferee. Correct answer is option B. That is, it only enacts the purchaser pendent light suit is bound by the result of the litigation. Question number 210. The doctrine of lis pendens is applicable during the pendency of the suit, after filing the suit, after disposal of the suit, before filing of the suit. Correct answer is option A, that is during the pendency of the proceeding. Question number 211. The doctrine of lis pendens would apply against the defendant who has transferred the immovable property from the date of filing of the plaint, service of notice, appearance before the court, hearing of the court. Correct answer is option A, that is filing of plaint. Question number 212. Transfer of property pending suit thereto, the transferor shall be void, affected by the decree or order of the court, illegal, infructuous. Correct answer is option B, that is affected by the decree or order of the court. Question number 213. The doctrine of lis pendens applies where the suit is collusive, the transfer is made after the decree of the trial court but before the filing of an appeal, right to movable property is in question, property is situated outside the territorial jurisdiction of the court. Correct answer is option B. The transfer is made after the decree of the trial court but before filing of an appeal. Question number 214. Lis pendens is not applicable to suit proceedings which is, options are ex parte, collusive, pending service of notice, in execution. Correct answer is option B, collusive. Question number 215. Which one of the following condition is not an essential condition for application of rule of lis pendens under section 52 of TPA? Options are pendency of a suit or proceeding, pendency in a competent court, suit must be collusive, alienation must affect the rights of the other party. Correct answer is option C, suit must be collusive is not an essential condition for the application of rule of lis pendens under section 52. Question number 216. A settlement made to defeat and defraud creditors is voidable in which section of TPA? Options are section 52, 53, 54, 55. Correct answer is option B, that is section 53. Question number 217. Under which section of TPA fraudulent transfer is defined? Options are section 21, section 35, section 53, section 41. Correct answer is section 53. Question number 218. Which section of TPA bars fraudulent transfers? Options are section 43, section 53, section 63, section 71. Correct answer is option B, that is section 53. Question number 219. Which of the following case decided by the Privy Council relates to fraudulent transfer? Correct case is Mushahar Sahu versus Hakim Lal. This is the right answer. Question number 220. Every transfer of immovable property made with intent to defeat the creditors of the transferor is voidable at the option of any creditors who defeated, void ab initio, voidable at the option of the transferee, none of the above. Here correct answer is option A, that is voidable at the option of any creditors who defeated. Question number 221. Part performance of a contract for sale of immovable property is contemplated under which section of TPA? Options are section 51, section 52, section 53, section 53A. Correct answer is section 53A. Question number 222. The doctrine of part performance cannot defeat the right of a transferee for value, gratuitous transferee for value if he has notice of the contract or his part performance, transferee for value and without notice of the previous contract of its part performance. Correct answer is option D, transferee for value and without notice of the previous contract of its part performance. Question number 223. What act does not constitute part performance? Options are delivery of possession, act done in performance of the contract, an unequivocal act which is referable to no other contract than alleged, acts introductory to and previous agreement. Here the correct answer is option D, that is act introductory to and previous to the agreement. Question number 224. Prabodh Kumar Das versus Dantamara Tea Company Limited case is related to which of the following doctrine? Options are A, doctrine of election, B, doctrine of lis pendens, C, doctrine of part performance, D, doctrine of priority. Correct answer is option C, that is doctrine of part performance. Question number 225. Which is not the ingredient of section 53A of TPA? Options are agreement for transfer, consideration, transferee has performed his part, movable property. Here correct answer is movable property. Question number 226. The case of Arif versus Jadunath is related to which of the following? Apportionment, fraudulent transfer, part performance, none of these. Here correct answer is option C, that is part performance. Question number 227. Provision of Section 53 of Transfer Property Act. The rights of the following transferee for consideration shall not be affected. Options are: who is a gratuitous transferee, who has notice of the contract, who has no notice of the contract, whether he has notice of the contract or no notice of the contract. Correct answer is option C, who has no notice of the contract. Question number 228. Which of the following is a leading case on the doctrine of part performance? Correct answer is option C. Mohammad Musa versus Ashok Kumar Ganguly is the leading case on the doctrine of part performance. Question number 229. To apply the doctrine of part performance laid down in section 53 of TPA, the transferee must be always ready and willing to discharge his part of obligation under the contract. The contract must be in writing and signed by the transferor, and the terms and conditions must be certain. The contract must be for value, not gratuitous. Option D, all of the above. Here correct answer is option D, that is all of the above. Question number 230. Which one of the following cases does not pertain to the doctrine of part performance? Options are: Arif versus Jadunath, Prabodh Kumar versus Dantemara Tea Company, Sardar Govind Rao Mahdik versus Devi Sahai, Ram Baram Prasad versus Ram Mohit Hazara. Here correct answer is option D. This case is not related to doctrine of part performance. Other three cases are related to doctrine of part performance. Question number 231. No right of action is conferred on a transfer in possession under an unregistered contract of sale. Which section of TPA contains these principles? Options are section 35, section 41, section 53, section 53A. Correct answer is section 53A. Question number 232. For part performance of the contract, which is not an essential ingredient? Options are: contract to transfer immovable property, contract is in writing and signed by the transferor on his behalf, transferee is in possession of the property, transferee has paid full consideration. Option D, transferee has paid full consideration, is not an essential ingredient for the part performance of contract. Question number 233. Which one is not essential for the doctrine of part performance? Options are: contract is for consideration, contract must be for movable property, must be in writing and signed by transferor, the transferee must have received the possession of the property. Here correct answer is option B. Contract must be for movable property is not the essential for the doctrine of part performance. Question number 234. Cooper versus Cooper 1874 relates to rules against property, doctrine of election, doctrine of part performance, transfer for unborn child. Here correct answer is option C, that is doctrine of part performance. Question number 235. Transferee of the part performance has right to protect his possession. Options are wrong. Right can accrue only after the payment of full consideration. Option C, right. Option D, delivery of possession is not necessary. Here correct answer is option C, that is right. Question number 236. The doctrine of part performance under the Transfer Property Act does not apply to. Options are: oral contract, standing timber, is subject matter is grass, D, all of the above. Correct answer is option D, all of the above. In these all, the doctrine of part performance doesn't apply. Question number 237. Under TPA, which one of the following is not correctly matched? Options are: transfer by ostensible owner, section 41, doctrine of part performance, section 53B, fraudulent transfer, section 53, doctrine of lis pendens, section 52. Here it has been asked which of the following is not correctly matched. Option B, doctrine of part performance, section 53B is not correctly matched. Question number 238. An easement is extinguished only when either the dominant or the servient heritage is completely destroyed. Option B, only when the same person becomes entitled to the absolute ownership of the whole of the dominant and servant heritage. Option C, both A and B. And option D, neither A or B. Correct answer is option C, that is both A and B. Question number 239. Match list 1 and list 2 and select the correct answer by using the codes given below. List 1. Condition restraining alienation is provided in section 10. Agreement to sell, right in personam, and sale, right in rem. Fraudulent transfer provided in section 53. By going through these matches, the correct code will be option C. Question number 240. List 1 and list 2. Condition restraining alienation. This we have already discussed, section 10. Contingent interest, section 21. Part performance, section 53A. Rule against perpetuity, section 14. By going through these matches, the correct code here will be option A. Question number 241 is also again match list 1 and list 2. Here Mushahar Sahu versus Lal Hakim Lal is fraudulent transfer. Madison versus Elderson is related to part performance. And Ram Kumar versus McQueen is related to transfer by ostensible owner. And MST Dhanpati versus Devi Prasad is related to doctrine of election. By going through these matches, the correct option will be option B. The definition of sale is contained in the Transfer Property Act 1882 in section 54. Question number 243. Dash is a transfer of ownership in exchange for a price paid or promised or part paid and part promised. Correct answer is option A, that is sale. Sale is a transfer of ownership in exchange for a price paid or promised or part paid and part promised. Question number 244. Section 54 of TPA deals with. Correct answer is option A, that is sale. Question number 245. Under TPA, sale is a transfer of an interest in a specific immovable property, a right to enjoy immovable property, ownership, none of the above. Here correct answer is option C, that is ownership. Sale is a transfer of ownership. Question number 246. According to section 54 of TPA, a contract for sale of immovable property create any interest in the property, create charge on the property, confer title on the property, a contract that a sale of such property shall take place on terms settled between the parties. Correct answer is option D, that is a contract of sale of such property shall take place on terms settled between the parties. Question number 247. Tangible immovable property of value of this amount or upward can be transferred only by a registered instrument. Here correct answer is option A, that is rupees 100. Question number 248. Sale under section 54 of TPA is a transfer of ownership in exchange for price paid, price promised, price partly paid and partly promised. All of the above are correct. Question number 249. Which one of the following is not an essential element of sale? Options are parties, subject matter, transfer of convenience, payment of price in cash. Here payment of price in cash is not an essential element of sale. Question number 250. Transfer of tangible immovable property of the value of rupees 100 can be made only by a registered instrument, by an unregistered instrument, by delivery of property, by placing the buyer in the possession of the property. Here option D is the right answer, that is by placing the buyer in the possession of the property. Question number 251. In Transfer Property Act, rights of seller and buyer are provided in. Options are section 64 to 66, section 67 to 77, section 78 to 80, section 55. Correct answer is option D, that is section 55. Question number 252. Which of the following is not a duty of the seller? Options are to produce title deeds, to disclose patent defects, to execute convenience, to pay the outgoings. Correct answer is option B, that is to disclose patent defects is not the duty of seller. Question number 253. What is incorrect? The liabilities of the seller is that he is to disclose to the buyer any material defect in the property, to produce to the buyer for examination all documents of title relating to the property, not to answer to the best of his information all the relevant questions put to him by the buyer in respect of the title. Option D, to give possession to the buyer as its nature admits. Correct answer is option C. Option C is incorrect. Other options are correct. Question number 254. In case of a transfer property, the seller is option A, not entitled to rents and profits. Option B, entitled to rents and profits of the property till the ownership thereof passed by buyer. Option C, entitled to rents and profits forever. And option D, none of the above. Here correct answer is option B, that is entitled to rents and profits and property till the ownership thereof passed by buyer. Question number 255. In which of the following sections of Transfer Property Act doctrine of marshalling has been provided? Correct answer is option A, section 56 to 81. Question number 256. Marshalling by subsequent purchaser is provided under TPA in. Correct answer is section 56. Question number 257. In which section of TPA the provision of mortgage are defined? Options are section 54, section 56, section 58, section 85. Correct answer is option C, that is section 58. Question number 258. Section 58 of TPA defines. Options are mortgager, mortgage, mortgaging money, all of these. Correct answer is option D, that is all of these. Question number 259. What is correct in case of mortgage deed? Options are mortgage is the transfer of an interest in a specific immovable property. In mortgage deed, ownership is not transferred. Principal amount of interest is mentioned in mortgage deed. All of these. Here correct answer is option D, that is all of these. In mortgage deed, mortgage is the transfer of an interest in specific immovable property. In mortgage deed, ownership is not transferred. Principal amount and interest is mentioned in mortgage deed. So all of these are the correct answer. Question number 260. Dash is defined as a security for repayment of loan. Correct answer is mortgage. Mortgage is defined as a security for repayment of a loan. Question number 261. Section 58 clause A of TPA defines mortgager, mortgagee and mortgage money. Option B, mortgage, mortgager, mortgagee and mortgage deed. Option C, mortgage, mortgager, mortgagee, mortgage money and mortgage deed. Option D, mortgage, mortgager, mortgage money and mortgager deed. Correct answer is option C. Under section 58A of TPA, mortgage, mortgager, mortgagee, mortgage money and mortgage deed are defined. Question number 262. How many types of mortgage are there in section 58 of TPA? Options are 4, 5, 6, 7. Here correct answer is option 6. There are 6 types of mortgage defined under section 58 of TPA. Question number 263. Which of the following is not an essential element of mortgage as defined in section 58 clause A of TPA? Options are there must be transfer of interest, there must be promise to transfer of interest, the interest must be some specific immovable property, the purpose of transfer must be to ensure payment of a debt. Here correct answer is option B. There must be promise to transfer of interest is not an essential element of mortgage. Question number 264. In which of the following mortgage the mortgager bind himself personally to pay the mortgage money? Options are simple mortgage, usufructuary mortgage, anomalous mortgage, mortgage by assurance. Correct answer is option A, that is simple mortgage. In simple mortgage, the mortgager binds himself personally to pay the mortgage money. Question number 265. Where possession of mortgage property is not delivered to the mortgagee, it is called simple mortgage, usufructuary mortgage, English mortgage, mortgage by conditional sale. Correct answer is option A, that is simple mortgage. Question number 266. Whether mortgage under simple mortgage can take possession of the mortgage property? No. Correct answer is option B. Question number 267. Every sale accompanied by agreement for reconveyance of property would not constitute mortgage by conditional sale. This statement is related to which section of Transfer of Property Act? Section 58. Question number 268. Whether simple mortgage must always be registered? Options are yes, if value of property is more than ₹100. Registration not necessary, none of the above. Correct answer is option A, yes. In simple mortgage, registration is always necessary. Question number 269. Which one of the following provision of TPA relates to usufructuary mortgage? Options are section 58 clause A, section 58 clause B, option C section 58 clause D, option D section 58 clause E. Correct answer is section 58 clause D. Question number 270. Where the mortgager delivers possession of the property to the mortgagee is called usufructuary mortgage. Question number 271. In which of the following mortgages the mortgager is required to deliver the possession of the mortgage property to the mortgagee? Options are English mortgage, mortgage conditional sales, usufructuary mortgage, anomalous mortgage. Correct answer is option C, that is usufructuary mortgage. Question number 272. In lieu of debt from B, handovers the possession of his house to B with the covenant to transfer of property in favor of B, but with the provisions for retransfer in case of repayment of debt. This type of mortgage is known as options A, equitable mortgage, English mortgage, usufructuary mortgage, mortgage by conditional sale. Correct answer is option B, that is English mortgage. Question number 273. The mortgagee has the right to sell the mortgage property without intervention of the court. Options are English mortgage, simple mortgage, anomalous mortgage, mortgage by conditional sale. Correct answer is option A, that is English mortgage. Question number 274. Where mortgagee is entitled to enjoy the benefits of the mortgage property in lieu of interest on debt, the mortgage is called usufructuary mortgage. Question number 275. In case of usufructuary mortgage, the mortgagee is placed in possession. He has a right to receive the rents and other profits. Option A, till the contract is rescinded, till the mortgage money is paid, for a fixed period of 30 years, for a fixed period of 99 years. Here correct answer is option B, till the mortgage money is paid. Question number 276. Where the mortgage delivers the possession of the mortgage property to the mortgagee, authorizing him to retain such possession until payment of the mortgage money and to receive the rent and profits accruing therefrom, such mortgagee is called, correct answer is usufructuary mortgage. Question number 277. Under which one of the following sections of TPA English mortgage has been defined? English mortgage has been defined in section 58 clause E. Question number 278. The mortgage which involves absolute transfer of the mortgage property with the provision of free transfer is mortgage by conditional sales, equitable mortgage, English mortgage, anomalous mortgage. Here correct answer is option C, that is English mortgage. Question number 279. A mortgage by deposit of title deeds is called anomalous mortgage, English mortgage, equitable mortgage, usufructuary mortgage. Correct answer is option C, that is equitable mortgage. Question number 280. Under TPA, which of the following mortgage with value of rupees 100 or above is not compulsorily registrable? Option are simple mortgage, mortgage by conditional sale, English mortgage, mortgage by deposit of title deeds. Correct answer is option D, that is mortgage by deposit of title deeds. Question number 281. To make a mortgage for 100 rupees or upward valid, it should be registered, signed by the mortgager and attested by at least 2 witnesses, but it is not applicable in the case of English mortgage, simple mortgage, usufructuary mortgage, mortgage by deposit of title deeds. Correct answer is option D, that is mortgage by deposit of title deeds. Question number 282. Writing and registrations are not required in which one of the following mortgages? Writing and registration is not required in mortgage by deposit of title deeds. Question number 283. In which case of the Supreme Court has held that the mortgage was valid even though no part of the mortgage money has been advanced? Correct answer is option B, State of Kerala versus Cochin Refineries, AIR 1968. Question number 284. A mortgage which is not a simple mortgage, a mortgage by conditional sale and usufructuary mortgage, an English mortgage or a mortgage by deposit of title deeds is called an anomalous mortgage. Question number 285. Which one of the following may fall under anomalous mortgage? Only mortgage, usufructuary by conditional sale, only simple usufructuary mortgage, both A and B, neither A or B. Correct answer is option C, that is both A and B. Question number 286. Which is not specifically mentioned as a kind of mortgage in the TPA? Correct answer is option A, that is equitable mortgage. Question number 287. Which one of the following kinds of mortgage is not included in section 58 of TPA? Options are anomalous mortgage, usufructuary mortgage, simple English mortgage, mortgage by deposit of title deeds. Correct answer is option C, that is simple English mortgage. Question number 287. Which out of the following kinds of mortgage is not included in section 58 of the TPA? Options are anomalous mortgage, usufructuary mortgage, simple English mortgage, mortgage by deposit of title deeds. Here it has been asked which of the following is not included. Simple English mortgage is not included, but in section 58, mortgage by conditional sale, usufructuary mortgage, English mortgage, mortgage by deposit of title deed and anomalous mortgage are included. Question number 288. A transfer his property to B by mortgage with a condition for 10 years. B will take the mortgage money from the income of the property and thereafter A shall redeem the property by making the payment of remaining amount. This mortgage is anomalous mortgage. Question number 289. Under Transfer Property Act, personal obligation to pay mortgage money accrues in. Correct answer is simple and English mortgages. Question number 290. Where the principal money secured is 100 rupees or upwards, the mortgage other than the mortgage by deposit of deed can be effected only by registered instrument signed by the mortgager, attested by at least 2 witnesses, all of the above. Here correct answer is option D. Question number 291. Which one of the following mortgage does not require writing and registration? Options are usufructuary mortgage, simple mortgage, English mortgage, mortgage by deposit of title deeds. Correct answer is option D, that is mortgage by deposit of title deeds. Question number 292. Which of the following transfer is valid? An unregistered usufructuary mortgage for rupees 99, an unregistered gift of immovable property of the value of rupees 99, an oral lease of immovable property from year to year, and oral assignments of debt. Here correct answer is option A, an unregistered usufructuary mortgage of rupees 99. This transfer is valid. Question number 293. If the sale and agreement to repurchase are embodied in separate documents, then the transaction cannot be a mortgage. This was laid down in, correct answer is 𝐶𝐤𝐴 versus Sheikh Ibadat Ali. Question number 294. Right of redemption arises in the case of gifts, mortgage, lease, exchange. Here correct answer is option B, mortgage. Right of redemption arises in the case of mortgage. Question number 295. From the following, who cannot sue for redemption of the mortgage property? Options are the mortgager, the mortgagee. Option C, surety for the payment of the mortgage debt. Option D, creditor of the mortgager who has in suit for the administration of his estate obtained a decree for sale of the mortgage property. Correct answer is option B, that is the mortgagee. Mortgagee cannot sue for the redemption of the mortgage property. Question number 296. The mortgager's right to redeem the mortgage property accrues, option A, at any time after the mortgage. Option B, at any time after the mortgage money has become due. Option C, at any time when the mortgager wants. And option D, at any time the mortgager demands the money. Here correct answer is option B, that is at any time after the mortgager money has become due. Question number 297. Right of redemption can be exercised only by paying the mortgager money to the mortgagee, only by depositing the mortgager money in the court, only by a regular suit for redemption, all of these. Here correct answer is option D, that is all of these. Right of redemption can be exercised only by paying the mortgager money to the mortgagee, only by depositing the mortgage money in court, and only by regular suit of redemption. Question number 298. Who among the following persons may not redeem the mortgage property? Options are any person having interest in the property, any surety for payment of the mortgage debt, any creditor of the mortgager. Option D, counsel pleading the case against mortgagee. Correct answer here is option D, that is counsel pleading the case against the mortgagee may not redeem the mortgage property. Other persons can redeem for the mortgage property. Question number 299. Mortgager's right of redemption is coextensive with. Options are mortgager's right to inspection and production of documents, mortgagee's right for foreclosure of sale, mortgager's right to redeem separately or simultaneously, and option D, all of these. Here correct answer is option B, that is mortgager's right of foreclosure or sale. Mortgager's right of redemption is coextensive with mortgager's right of foreclosure or sale. Question number 300. Which among the following is false statement about the term clause of redemption? Options are it is an absolute right, it is a statutory right, it can be fettered by any condition, and option D, any condition contained in mortgage deed which obstruct the right of redemption will be null and void. Here it has been asked which of the following is false statement about the term clause of redemption. Therefore option C is the right answer. It can be fettered by any condition is a false statement regarding clause on redemption. Question number 301. Once a mortgage, always a mortgage means option A, mortgager has no right to assign right of redemption to any person. Mortgagee has no right to assign the mortgagee debt to any other person. Mortgage cannot be redeemed after the expiry of a fixed period. Mortgage is always redeemable. Here correct answer is option D, that is mortgage is always redeemable means once a mortgage, always a mortgage. Question number 302. The principle once a mortgage, always a mortgage, a principle based on equity, justice and good conscience, was the first time evolved in option A, Harris versus Harris, option B, Noakes versus Rice, option C, Seth Gangadhar versus Shankar Lal, and option D, Reeve versus Lisle. Here correct answer is option B, that is Noakes versus Rice. Question number 303. Redemption is the heart of mortgage was observed by Correct answer is Lord Halsbury. Question number 304. Which of the following case is related to right of redemption? Correct answer is option D, all of the above cases. That is Stanley versus Wild, Noakes versus Rice, Curlinger versus New Pentagonia Meat and Cold Storage Company Limited. All the cases are related to right of redemption. Question number 305. In which section of TPA doctrine of consolidation is incorporated? Doctrine of consolidation is incorporated in section 61 of TPA. Question number 306. A mortgagor who has executed two or more mortgages in favor of the same mortgagee in absence of a contract to the contrary is bound to redeem all such mortgages together, is not entitled to redeem any one such mortgage separately, is bound to redeem at least two such mortgages together, be entitled to redeem any one of such mortgages separately or any two or more of such mortgages together. Here correct answer is option D, that is be entitled to redeem any one such mortgage separately or any two or more such mortgages together. Question number 307. Which of the following sections deals with the accession to mortgage property? Options are section 63, section 70, option C section 63 and section 70 both, and option D section 63A. Here correct answer is option C, that is section 63 and section 70 both. Question number 308. Mortgage property in possession of the mortgagee has during the continuance of the mortgage received any accession upon redemption in absence of the contract to the contrary. Who shall be entitled to such accession? Option A, mortgagee, option B, mortgagor, and option C, mortgagee and mortgagor in equal share, and option D, none of the above. Here correct answer is option B, that is mortgagor. Question number 309. Whether a mortgagor can make lease of mortgage property? Options are absolutely yes, option B, yes with certain conditions provided by the Transfer of Property Act, no, none of the above. Here option B is the correct answer, yes with certain conditions provided by the TPA. Question number 310. In case of mortgage lease, if the mortgagor obtains a renewal of the lease, the mortgagor upon redemption shall not have the benefit of new lease, shall have the benefit of a new lease, shall have the benefit of previous lease, none of the above. Here correct answer is option B, that is shall have the benefit of new lease. Question number 311. Section 65 of TPA contains provisions relating to implied contracts by mortgagor. Option A is the correct answer. Question number 312. Improvements to mortgage property is provided in which section of TPA Act? Correct answer is option B, that is section 63A. Question number 313. Right to foreclosure or sale has been provided in which sections of TPA? Correct answer is option C, that is section 67. Question number 314. Which is a right of the mortgagee and not that of mortgagor? Options are right to foreclosure, right to redeem, right to recover possession, right to inspect documents. Correct answer is option A, that is right to foreclosure. Right to foreclosure is a right of mortgagee and not of mortgagor. Question number 315. A right to obtain a decree from the court that the mortgagor shall be absolutely debarred of his right to redeem the mortgaged property is called right of foreclosure. Question number 316. Under TPA, remedy of foreclosure is available under which one of the following mortgages? Mortgage by conditional sale, English mortgage, usufructuary mortgage, simple mortgage. Correct answer is option A, that is mortgage by conditional sale. Question number 317. The in TPA, rights and liabilities of mortgagee is provided under option A, section 55 to 57, option B, section 61 to 65, and option D, section 67 to 77, and option D, section 78. Here correct answer is option C, that is section 67 to 77, rights and liabilities of mortgagee is provided. Question number 318. The mortgagee has a right to sue for the mortgage money in the following cases, namely option A, section 68 subsection 1 clause C, where the mortgage is deprived of whole or part of his security by or in consequence of the wrongful act or default of the mortgagor, and option B, section 68 clause 1D, section 68 subsection 1 clause D, where the mortgagee being entitled to the possession of the mortgage property, the mortgagor fails to deliver the same to him or to secure the possession thereof to him without disturbance by the mortgagor or any person claiming under title superior to that of the mortgagor. Option C, both A and B, and option D, none of the above. Here correct answer is option C, that is both A and B. Question number 319. Which section of TPA provides provisions relating to appointment of receiver? Correct answer is section 69A, option D. Question number 320. Which section of the following provisions of TPA provides the statutory duties of a mortgagee in possession? Here correct answer is section 76. Question number 321. Which one of the following sections of TPA deals with the doctrine of substituted security? Correct answer is section 73. Section 73 deals with the doctrine of substituted security. Question number 322. Which one of the following section provides statutory duties of the mortgagee in possession under the TPA? Options are section 78, section 76, section 77, section 79. Here correct answer is option B, that is section 76. Question number 323. The rule entitling a subsequent mortgagee to compel prior mortgagee of two properties to satisfy the latter's mortgagee's debt out of the property not mortgaged to the former is called the rule of option A, subrogation, option B, contribution, option C, marshalling, and option B, tacking. Here correct answer is option C, that is marshalling. Question number 324. Rules relating to marshalling securities is described in TPA under section 81. In section 81, rules relating to marshalling securities is described. Question number 325. Which of the following sections of TPA provides that when there is a conflict between marshalling and contribution, marshalling shall prevail? Correct answer is option C, that is section 82. Question number 326. The principle of marshalling and contribution is a principle under the Law of Transfer of Property Act which relates to the matter of option A, deposit, option B, lease, option C, security, and option D, gift. Here correct answer is option C, that is security. Question number 327. Section 81 of TPA contains provisions relating to marshalling of securities, contribution to mortgage debt, subrogation, taking of securities. Here correct answer is option A, that is marshalling of securities. Question number 328. In chapter 4 of TPA, contribution is related to mortgagors, marshalling is related to option A, mortgagees, option B, prior mortgagees, option C, co-mortgagees, and option D, subsequent mortgagees. Here correct answer is option D, that is subsequent mortgagees. Question number 329. Which of the following is not correctly matched under TPA? Universal Dole, section 128 is correctly matched. Doctrine of part performance, section 53A is also correctly matched. Marshalling by subsequent purchaser, section 65, this is not correctly matched. Mortgagees right to foreclosure or sale, section 67, this is the correct match. By going these matches, the correct option for question number 329 will be option C, because it has been asked not correctly matched. C is not correctly matched. Question number 330. Which of the following sections of TPA provides for subrogation? Options are section 90, section 92, section 91, section 93. Correct answer is section 92. Section 92 provides for subrogation. Question number 331. Doctrine of subrogation applies to sale, mortgage, lease, gift. Correct answer is option B, that is mortgage. Question number 332. The doctrine of subrogation enables third person to stand in the shoes of a creditor, creditor to sue the debtor, debtor to postpone the payment, includes all of these. Correct answer is option A, that is third person to stand in the shoes of a creditor. Question number 333. Which out of the following is not a kind of mortgage? Options are mortgage by conditional sales, usufructuary mortgage, English mortgage, subrogation. Correct answer is option D, that is subrogation is not a kind of mortgage. Question number 334. State the correct answer. The familiar rule, redeem a foreclosure down, is a combination of provisions of option A, section 89 and 91, option B, section 91 and 92, option C, section 92 and 93, and option D, section 91 and 94. Here correct answer is option D, that is section 91 and 94. Question number 335. Which one of the following sections of TPA defines charge? Charge is defined in section 100 of TPA. Option A is correct answer. Question number 336. Within section 100 of TPA, a charge, option A, requires attestation and proved in the same way as a mortgage. Option B, requires attestation and does not prove as a mortgage. And option C, does not require to be attested and proves in the same way as mortgage. And option D, does not prove as a mortgage. Here the correct answer is option C, that is does not require to be attested and prove in the same way as mortgage. Question number 337. Under TPA, a charge may be created. Option A, act of the parties. Option B, process of law. Option C, presumption. Option D, act of parties and process of law. Here correct answer is option D, that is act of parties and process of law. Question number 338. Under section 104 of Transfer of Property Act, whom the power of making rule is conferred? Options are central government, state government, Supreme Court, High Court. Correct answer is option D, that is High Court. Under section 104 of TPA, High Court have the power of making rules. Question number 339. Match list 1 and list 2 and select the correct answer by using the quotes given below. Feeding the grant by estoppel. Here correct answer is section 43. Doctrine of subrogation. Correct answer is section 92. Doctrine of accumulation. Correct answer is section 17. And rule against perpetuity. Correct answer is section 14. By going through these matches, the correct quotes will be option A. Question number 340. The following leading case are related to which of the following subjects? Options are option A, Gopal versus Purushottam, Stanley versus Wild, Kedar Lal versus Hari Lal, Ali Hussain versus Nilla Kandan. Choose the correct answer. Option A, lease. Option B, gift. Option C, mortgage. And option D, none of the above. Correct answer is option C, that is mortgage. Question number 341. Which one of the following group of sections deals with the lease under TPA? Options are section 102 to section 119, option B section 105 to 119, option C section 102 to section 117, and option D section 105 to section 117. Here correct answer is option D, that is section 105 to 117 deals with the lease under TPA. Question number 342. Lease under section 105 of TPA pertains to a lease of immovable property, a lease of movable property, both movable and immovable and movable property, and option D does not to any particular property. Here correct answer is option A, lease of immovable property. Question number 343. Transfer of right to enjoy an immovable property in consideration of price is known as option A, mortgage, option B, actionable claim, option C, lease, and option D, license. Here correct answer is option C, that is lease. A lease is a right to enjoy an immovable property in consideration of a price. Question number 344. Which type of property may be used for lease? Options are only movable, only immovable, and option C, movable and immovable both, and option D, none of these. Here correct answer is option B, that is only immovable property can be used for lease. Question number 345. In a lease of immovable property, what is transferred is the correct answer is option A, that is right to enjoy the property. Question number 346. In view of section 105 of TPA, a lease of immovable property is transfer of, options are a right to enjoy such property in consideration of a price paid or promised, or of money, a share of crops, services, or any other thing of value. This is the correct answer. Option A is correct in question number 346. Question number 347. A lease to a minor is void. Question number 348. A lease can be made for a certain period only, for perpetuity only, and option C, none of the above, option D, A and B both. Correct answer is option D, that is A and B both. A lease can be made for a certain period as well as for perpetuity also. Question number 349. A lease of an immovable property can be for a limited period in perpetuity, can be express or implied, all of the above. Correct answer is option D, that is all of the above. Question number 350. In which one of the following sections TPA an amendment was made in the year 2002? Section 100, section 106, section 108, section 110. Correct answer is option B, that is section 110. In 2002, an amendment takes place in section 106. Question number 351. The provisions of section 106 of Transfer Property Act was substituted by the Transfer Property Amendment Act 2002, and this provision came into force with the effect from. Correct answer is December 31, 2002. Option A is the right answer. Question number 352. According to the amendment to the Transfer Property Act 2002, The period within the principal clause of section 106 of the Act shall commence from option A, date of the receipt of notice, date of issue of notice, date of summoning of notice, 15 days from the expiry of notice. Correct answer is option A, that is date of receipt of notice. Question number 353. In absence of a written contract, a lease of immovable property for the purpose other than the agriculture or manufacturing shall be deemed to be a lease from month to month, terminable by 15 days notice. The period shall commences from the receipt of notice. Option B is the right answer. Question number 354. In the absence of a contract or local law or usage, a lease of immovable property for manufacturing purposes shall be deemed to be option A, a lease for year to year, option B, a lease for month to month, option C, a lease for minimum term of 2 years, and option D, a lease for a minimum term of 3 years. Here correct answer is option A, that is a lease for a year to year. Question number 355. A lease of immovable property from year to year is terminable on the part of the lessor or lessee by the notice of 6 months. Option B is the correct answer. Question number 356. Under the Transfer Property Act, in the absence of a contract or local law, monthly lease is terminable by 15 days notice expiring. Option A is the right answer. Question number 357. Generally, a lease of immovable property for agriculture purposes shall be a lease from year to year. Option A is the right answer. Question number 358. Which out of the following does not constitute agricultural lease? A lease for rearing tea plants, a lease for cultivation of indigo, a lease for cultivation of potatoes, a lease for gathering fruits from trees. Option D does not constitute agricultural lease, therefore option D is the correct answer, and A, B, C option related to agricultural lease. Question number 359. Termination of lease of immovable property shall be in the following manner. And option B, by written notice is the correct answer. Termination of lease should be by written notice. Question number 360. A lease of immovable property from year to year can be made by oral agreement accompanied by delivery of possession, simple instrument, only by a registered instrument. Option D is the right answer, that is only by a registered instrument. Question number 361. Under the Transfer Property Act, leases from month to month can be made. Option A, by oral agreement, B, by oral agreement accompanied by delivery of possession only, C, either by a registered instrument or by oral agreement accompanied by delivery of possession, option D, by a registered instrument only. Here correct answer is option C, that is either by a registered instrument or by local agreement accompanied by delivery of possession. Question number 362. In the following 3 cases, which lease of immovable property can be made only by a registered instrument? Options are only a lease from year to year, only a lease from term exceeding 1 year, only a lease reserving yearly rent. All of these. Correct answer is option D, that is all of these. Question number 363. A lease of immovable property for any term exceeding 1 year can be made only by a registered instrument, by oral agreement accompanied with delivery of possession, either by oral agreement by a registered instrument. Here correct answer is option A, that is only by a registered instrument. Question number 364. Where a lease of immovable property is made by a registered instrument, such instrument shall be executed by lessor only, by lessee only, by either of the two, by both the lessor and the lessee. Here correct answer is option D, that is by both the lessor and the lessee. Question number 365. In the section of Transfer Property Act, the provisions regarding rights and liabilities of the lessor and lessee are provided in Section 107, Section 108, Section 109, Section 110. Correct answer is option B, that is Section 108. Question number 366. Determination of lease dealt with under the Transfer Property Act 1882 in Section 108, Section 107, Section 113, Section 111. Correct answer is option D, that is Section 111. Question number 367. In which one of the following conditions lease can be terminated? Option A, efflux of time. Option B, on termination of lessor's interest on power. Option D, on merger, and option D, all of the above. Correct answer is option D, that is all of the above. Question number 368. In which one of the following cases a lease of immovable property does not determine? Option A, on the service of a notice to quit. Option B, by forfeiture, or option C, by express surrender, by option D, by efflux of time limited thereby. Correct answer is option A, that is on the service of a notice to quit. Question number 369. Which one of the following is not a ground for determination of lease? Option R, efflux of the time limited, implied surrender. Option C, expiration of notice for determination of lease. Option D, death of the lessee. Here correct answer is option D, that is death of the lessee is not a ground for the determination of lease. Efflux of time limited period, implied surrender, expiration of notice and determination of lease are the ground for determination of a lease. Question number 370. A notice under Article Section 111 of the TPA can be Waived. Option A, by express or implied consent of the person to whom it is given. Option B, by implied consent of the person to whom it is given. Option C, by express consent of the person to whom it is given by notice from either party. Here correct answer is option A, that is by express or implied consent to the person to whom it is given. Question number 371. A valid lease can be determined by efflux of time, forfeiture, on expiration of the notice period determination of such lease. All of the above. Correct answer is option D, that is all of the above. Question number 372. A lessee accepts from the lessor a new lease of the property base to take effect during the continuance of the existing lease. This converts the former lease into exchange, converts the former lease into a perpetual lease, is an implied surrender of the former lease, is a voidable agreement. Here correct answer is option C, that is an implied surrender of the former lease. Question number 373. Waiver of forfeiture under section 112 takes place by acceptance of rent which has become due since the forfeiture, by distress of such rent, by other act on the part of the lessor showing an intention to treat the lease as subsisting, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 374. Which of the following is a ground for determination of a lease by forfeiture? Option A, on breach of express condition, on expiry of lease period, on surrender by lessee, on vesting of lessor's interest in the lessee. Here correct answer is option A, that is on breach of express condition. Question number 375. A lets a house to B for 5 years. B underlets the house to C at a monthly rent of ₹1,000. The 5 years expire, but C continues in the possession of the house and pays the rent to A. C's lease is renewed from month to month. Option A is the correct answer. Question number 376. What is the effect of holding over? The lease is renewed. Option B. Question number 377. Ashok lets a house to Bharat for 5 years. Bharat underlets the house to Kishore at a monthly rent of ₹2,000. 5 years expire, but Kishore continues in the possession of the house and pays the rent to Ashok. What is the status of Kishore? Here correct answer is option A, that is tenant holding over. Question number 378. A lets a farm to B for the life of C. C dies. B continues in possession with A's assent. B's lease is option A, determined. Option B, renewed from year to year. Option C, renewed forever. And option D, renewed for the year of death. Here correct answer is option B, that is renewed from year to year. Question number 379. In a Transfer Property Act, effect of holding over of a lease is provided under Section 114A, Section 115, Section 116, Section 117. Correct answer is option C, that is Section 116. Question number 380. Exemption of a leases for agriculture purposes. Option A, Section 116. Option B, Section 117. Option C, Section 115. Option D, Section 114. Here correct answer is option B, that is Section 117. Question number 381. An act of interference with the property of another may be justified by the consent of that other is defense falling under option A, authority of law. Option B, lease and license. Option C, easement. And option D, none of the above. Correct answer is option B, lease and license. Question number 382. Which of the following statements are true to ascertain whether a document creates a license or a lease? Options are: if the document creates an interest in the property, it is a lease. However, if it only permits another to make use of property of which legal possession continues to with the owner, it is a license. Option B, the real test is the intention of the parties, whether they intend to create a lease or a license. Option third, the substance of the document must be preferred to the form of the document. Option fourth, if the party gets exclusive possession under the document, he is a prima facie a tenant, but the circumstances may be established which negate the intention to create a lease. Select the correct answer. Only first and third are correct. Only first and second are correct. Only third and fourth are correct. And option D, all are correct. In question number 382, option D is all are correct. All these above statements are correct. Question number 383. Which one of the following transfers can be made orally? Options are: lease from year to year, surrender of lease, exchange of immutable property exceeding ₹100, simple mortgage. Here correct answer is option B, that is surrender of lease can be made orally. Question number 384. Column 1 and column 2 we have to match. Definition of lease. Definition of lease is provided in section 105. Duration of lease is provided in section 106. Determination of leases is provided in section 111, and definition of gift is provided under section 122. So by going these matches, the correct combination will be option D. Question number 385. Two persons mutually transfer the ownership of one thing for the ownership of another. The transaction is called option A gift, option B exchange, option C sale, option D lease. Correct answer is option B exchange. Question number 386. In exchange, under which provisions of Transfer of Property Act, which of the following statement is true? Option A, there is a consideration, there is no consideration, there is no transfer of property, none of the above. Here correct answer is option A, there is consideration. Question number 387. Ram transfer a house worth rupees 5 lakhs to Shyam in lieu of a field worth rupees 2 lakhs and rupees 3 lakhs as cash. The transfer is a sale, an exchange, neither a sale nor an exchange, a settlement. Correct answer is option B, that is an exchange. Question number 388. The provision as to exchange of money has been provided under which of the following section of Transfer Property Act? It is provided in section 121 of TPA. Question number 389. Exchange to Transfer Property Act is equal to partition, gift, sale. None of these. Exchange is distinct from partition, gift and sale. Question number 390. Gift of tangible immovable property of value less than rupees 100 can be made under the Transfer Property Act. Option A, by oral agreement accompanied with delivery of possession only, by registered instrument only, by registered instrument attested by at least 2 witnesses, either by oral agreement or by registered deed. Here correct answer is option C, that is by a registered instrument attested by at least 2 witnesses. Question number 391. If A transfers house worth rupees 2000 to B and B transfers field of rupees 1200 in addition to pay rupees 800 in cash to A, the transfer is exchange, sale, sale in exchange, none of these. Correct answer is option A, that is exchange. Question number 392. Which of the following is not correctly matched? Direction for accumulation, section 17, correct. Mortgages power to lease, section 55A, correct. Transfer by one co-owner, section 44, correct. Exchange of money, section 120. This is not correct. Option D is not correct. Question number 393. Gift is defined in which section of the TPA? Gift is defined in section 122 of Transfer Property Act. Question number 394. Section 122 of TPA deals with which of the following kinds of gift, namely gift inter vivos, gift moritis causa, gift by will, all of the above. Correct answer is option A, that is gift inter vivos. Question number 395. According to section 122 of Transfer Property Act, property includes only movable property, only immovable property, both movable and immovable property, agricultural land only. Here correct answer is option C, that is both movable and immovable property. Question number 396. Which of the following is not an essential element of gift? Options are donor and donee, subject matter, transfer of subject matter, transfer must be for consideration. Here correct answer is option D, that is transfer must be for consideration is not an essential element of gift, whereas donor and donee, subject matter, transfer of subject matter are the essential elements of gift. Question number 397. A gift in favor of an unborn child is valid, irregular, voidable, void. It will be void. Question number 398. Transfer of immovable property by way of gift requires registered instrument signed by or on behalf of donor, attestation by at least 2 witnesses, delivery of the property, both A and B. Here correct answer is option D, that is both A and B, registered instrument signed by or on behalf of donor, attestation by at least 2 witnesses. Question number 399. In case the donee dies before acceptance of the gift, the said gift under the Transfer Property Act is void. Question number 400. Find out the incorrect answer from the following. Options are gift is a transfer of ownership without consideration. Gift should be accepted during the lifetime of the donor. If donee dies before acceptance, the gift is void. Gift may be made only of movable property. 400. Question number 400. Option D is incorrect, therefore will be the right answer. Gift can be of movable as well as immovable property. Question number 401. Which of the following is the correct respect of a gift under Transfer Property Act? Options are: there cannot be a gift of movable property. Only immovable property can be given in gift. The gift must be accepted by the donee only. If the donee dies before acceptance, the gift is void. Here, option D is correct response regarding gift. Question number 402. The registration of a gift of immovable property is compulsory, optional, compulsory in relation to ancestral property, depends of the court. Correct answer is option A, that is compulsory. Question number 403. Which one of the following statement is incorrect regarding the transfer of immovable property by gift? Options are: instrument must be signed by or on behalf of the donor. Instrument must be signed by the donor only. Instrument must be registered. Instrument must be attested by at least 2 witnesses. Here in this question it has been asked which of the following is incorrect. So option B is incorrect, that instrument must be signed by the donor only. This is incorrect. Both donor and donee will be the right answer. Question number 404. How many witnesses are required in a registered gift deed? Correct answer is option C, that is 2. Question number 405. As per section 122 of Transfer Property Act, gift means the transfer of certain existing movable property made by the donor to donee, the transfer of certain existing immovable property by the donor to the donee, the transfer of property by donor to donee on certain consideration, and option D, the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called a donor to another called a donee and accepted by or on behalf of the donee. Here correct answer is option D. Question number 406. Read the following propositions, find out which is incorrect. Option A, in sale there is an absolute transfer of all rights in the property sold and no rights are left in the transferor. Option B, in a lease there is a partial transfer or demise and the right left in the transferor are called reversion. Option C, a gift comprising both existing and future proportion is void as to the latter. Option D, acceptance is not the pivotal requirement to constitute a valid gift. Here it has been asked which of the following proposition is incorrect. Option D is incorrect. Other options are correct. So option D will be the right answer. Question number 407. A gift is statutorily not complete unless it is accepted by the donee. Such acceptance needs to be in writing by or on behalf of the donee, made during donor's lifetime, made while the donor is still capable of giving, made during donor's lifetime and while the donor is still capable of giving. Here correct answer is option B, that is made during the donor's lifetime. Question number 408. Which of the following statement is true regard to section 123 of TPA? Options are: it provides an exception to section 17 subsection 1 clause A of the Registration Act. Option B, it is supplemental of the section 17 subsection A clause A of the Registration Act. Here option B is correct answer. It is supplemental of section 17 subsection 1 clause A of the Registration Act. Question number 409. A gift of immovable property can be given by delivery of immovable property, by written statement, by delivery and registration of the document, none of the above. Correct answer is option C, by delivery and registration of the document. Question number 410. Under Transfer Property Act, gift of future property is void. Gift of future property will be void. Question number 411. When a gift is made of a property which is not in existence, which one of the following sections of the Transfer Property Act declares it void? It is declared void by under section 124 of Transfer Property Act. Question number 412. A gift comprising both existing and future property is void as to the future property and will be valid for the existing property. Question number 413. The chapter deals that gift under Transfer Property Act 1882 applies to Mohammedan gift also, does not apply to Mohammedan gift, applies to all caste, creed, etc., applies to Parsi gift only. Correct answer is option B, does not apply to Mohammedan gift. Question number 414. Where gift is made of a property which is not in existence, which of the following sections of the Transfer Property Act declares it void? Options are section 122, section 123, section 124, section 125. Correct answer is option C, that is section 124. Question number 415. Which of the following gift is not governed by the Transfer Property Act 1882? Options are onerous gift, mortis causa gift, universal gift, gift to disqualified person, none of these. Here correct answer is option B, This gift is not governed by the Transfer Property Act. Onerous gift, universal gift, gift to disqualified person are governed by the Transfer Property Act. Question number 416. A deed of gift is executed, attested and delivered to the donee. The donee accepted the gift. Before registration of the deed, the donor seeks to revoke the gift. Advise the donee. It can be revoked as it was not registered. Gift is not complete, therefore it is revocable. Gift is complete, the deed may be registered later on. He should wait till registration is done. Here correct answer is option C, that is gift is complete, the deed may be registered later on. Question number 417. A makes a gift of rupees 50,000 to B. A reserves the right with B's consent to take back at a pleasure of rupees 10,000 out of rupees 50,000. Here in this case, gift is valid up to rupees 40,000 and void as to the taking back of rupees 10,000. Question number 418. A gives a lakh of rupees to B, reserving himself B's assent the right to take back at the pleasure of rupees 10,000 out of lakh. The gift is holds good as to rupees 90,000. Question number 419. A makes a gift of rupees 80,000 to B, but A reserves right with B's consent to take back at the pleasure of rupees 30,000. What will be the legal status of the gift? Here, gift is valid up to rupees 50,000. Question number 420. A gives the field to B, reserving to himself with B's assent the right to take back the field in case B and his descendants dies in A's lifetime. Can A take back the field? Correct answer is option A, yes. Question number 421. A gift can be revoked in any of the cases in which might be rescinded if it were a contract except for want of consideration, allegations of fraud and undue influence, coercion, all of the above. Correct answer is option A, that is want of consideration. Question number 422. A transfer a house having market value of rupees 10,000 without consideration to B, but the house is under liability to pay public charges of rupees 15,000. The transfer is gift, onerous gift, actionable claim, none of these. Here correct answer is option B, that is onerous gift. Question number 423. The provisions relating to onerous gift have been provided under Transfer Property Act 1882 in section 127. Question number 424. Which one of the following section of TPA defines universal donee? Section 128 defines universal donee. Question number 425. Where a gift consists of the donor's whole property, the donee is personally liable for all the debts due by the donor at the time of the gift to the extent of the property comprised therein. It may be described as onerous gift, exchange, universal donee, transfer of actionable claim. Correct answer is universal donee. Question number 426. A donee which has taken all the properties of the donor and also liable to discharge all the liabilities of the donor is known as universal donee. Question number 427. Universal donee is liable to the creditors of the donor. The liability of the donee is personal to the extent of the value gifted of the property in hand. B is the correct answer. Question number 428. A universal donee gets the ownership of whole property, the whole property and donor's property in litigation, donor's property and liabilities of the donor in respect of all the debts due. C is the correct answer. Question number 429. Which section of the Transfer Property Act reserves the rule of Mohammedan law and excludes the applicability of section 123 of TPA, which mandates that a gift is immovable, must be effected by a registered instrument as stated therein? Correct answer is option D, that is section 129 of TPA. Question number 430. Which of the following gift is valid under Transfer Property Act? Gift to a minor, gift of a future property, gift accepted after donor's death, gift motivated by post-illicit cohabitation. Here correct answer is option A, gift to a minor is valid gift. Question number 431. The provisions regarding the transfer of actionable claims are mentioned under the Transfer Property Act in section 130, section 122, section 127, section 128. Correct answer is option A, that is section 130. Question number 432. An actionable claim can be transferred by a registered instrument, an instrument in writing signed by the transferor, a registered instrument attested by two witnesses, oral agreement. Correct answer is option B, that is an instrument in writing signed by the transferor. Question number 433. It is mandated that the transfer of an actionable claim can be effected only by an instrument in writing, but it does not have effect on negotiable instrument, arrears of rent, an amount due under the letter of credit, none of the above. Correct answer is option A, that is negotiable instruments. Question number 434. Which of the following is not an actionable claim under the Transfer Property Act 1882? Options are right to claim money payable under Life Insurance Act, right to claim decretal sum, right to claim arrears of rent of a house, right to claim arrears of maintenance. Correct answer is option B. Right to claim decretal sum is not an actionable claim. Question number 435. Which one of the following pair is correctly matched? Options are universal doni section 128A, mortgage debt section 134, exchange of money section 120, option D, all of the above. Here correct answer is option B, that is mortgage debt section 134 is correctly matched. Question number 436. Actionable claim means a claim to unsecured debt, a claim to beneficial interest in the movable property not in the possession of the claimant. Option C, both A and B, and option D, only A. Here option C is the right answer. Actionable claim means a claim to unsecured debt and also a claim to beneficial interest in movable property not in the possession of the claimant. Question number 437. Which from the following is not an actionable claim? Options are lottery tickets, option B, beneficial interest in movable property which is in the possession of a claimant, life insurance policy, claim for arrears of rent. Here question number 437, correct answer is option B, beneficial interest in movable property which is in the possession of a claimant is not an actionable claim. Question number 438, which among the following is recognized as actionable claims? Options are future decree, copyright of a book, claim for men's profit, arrears of rent. Correct answer is option D, that is arrears of rent is recognized as actionable claims. Question number 439, which of the following is an actionable claim? Options are a decree, a right to recover profits from a co-sharer, a claim to any debt other than the debt secured by the mortgage of immovable property, right to recover damages by way of interest for breach of contract. Correct answer is option C, that is a claim to any debt other than a debt secured by mortgage of immovable property. Question number 440. Bharat Nidhi Limited versus Takht Mahal AIR 1969 is related to option A, actionable claim section 130, ostensible honor section 41, election section 35, notice section 3. Here correct answer is option A, actionable claim section 130. Question number 441. Under the Transfer Property Act, which one of the following properties may be transferred? Options are an easementary right from the dominant heritage, mere right to sue, right to future maintenance, actionable claim. Correct answer is option D, that is actionable claim. Question number 442. Which one of the following is not an actionable claim? A claim for mensne profit is not an actionable claim, therefore will be the right answer because this has been asked in the question. A claim for arrears of rent is an actionable claim, a share in partnership actionable claim, a claim for return of the earnest money are all actionable claim. Question number 443. Who among the following cannot sell and purchase an actionable claim? Options are only judge, only legal practitioner, only any judicial officer. Correct answer is option D, that is all of these cannot sell and purchase an actionable claim. Question number 444. Match list 1 and list 2. Doctrine of election section 35, doctrine of subrogation section 92, doctrine of holding over section 116, and waiver of forfeiture. Correct answer is section 112. By going through these matches, the correct code here will be option A. Question number 445. Which of the following pair is correctly matched? Options are marshalling by subsequent purchasers section 81, right of mortgagor to redeem section 60A, right of usufructuary mortgagor to receive possession section 62, none of the above. Here it has been asked which of the following pairs is correctly matched. Correct answer is option C, right of usufructuary mortgage to recover possession section 62. Question number 446. Doctrine of subrogation. Correct answer is section 92. Rule against perpetuity. Correct answer is section 14. Feeding the grant by estoppel. Correct answer is section 43. And doctrine of accumulation. Correct answer will be section 17. Here, by going through these matches, the correct answer will be option A. Question number 447. In which transaction no interest in the property is created? Options are lease, license, mortgage, tenancy. Here correct answer is option B, that is license. In license, no interest in the property is created. Question number 448. Before the commencement of the Transfer Property Act, the transfer of immovable properties were governed by the principles of English Law and Equity, Indian Registration Act, British State of Goods Act, Indian Contract Act. Correct answer is option A, that is principle of English Law and Equity. Question number 449. The Bill on Transfer Property Act was referred to First Law Commission, Second Law Commission, Third Law Commission, Fourth Law Commission. Correct answer is option C, that is Third Law Commission. Question number 450. The Transfer Property Act extend in first instance to the whole of India except option A, territories which immediately before the 1st November 1956 were comprised in Part B states or in the state of Bombay, Punjab and Delhi. This statement is correct. Therefore, correct answer here will be A. Question number 451. According to Section 5 of the Transfer Property Act 1882, living person includes option A, company or association or body of individuals, individual human beings only important company or association, none of the above. Here correct answer is option A, that is company or association or body of individuals. Question number 452. Under the provisions of Section 6 of Transfer Property Act, a mere right of re-entry for breach of a condition subsequent cannot be transferred to anyone except the owner of the property affected thereby. Option A, the statement is true. Option B, the statement is false. Option A, the statement is partly true, and option D, none of the above. Here correct answer is option A, the statement is true. Question number 453. Under which provision of Section 9 of the TPA the transfer includes? Also oral transfer, written transfer only A is correct, only B is correct. Here correct answer is option A, transfer also includes oral transfer. Question number 454. Possession of a manager cannot be treated as ostensible ownership with the consent of the real owner. This was held in the case of Shishu Mullah versus M. Shah versus Sayyid Abdul Rashid, AIR 1991. Question number 455. The object of Section 57 of TPA is to option A, facilitate the sale of encumbered estates by taking the encumbrances of the title before sale. Option B is not to facilitate the sale of encumbered estates by taking the encumbrances of the title before sale. Option C, only B is correct, and option D, none of the above. Here correct answer is option A, facilitate the sale of encumbrances estates by taking the encumbrance of the title before sale. Question number 456. Within the meaning of Section 58 of Transfer Property Act, a mortgage is a transfer of an interest in a specific immovable property as a security for the repayment of debt. Here options are: such interest itself is immovable property, such interest is not immovable property, question of interest does not arise, none of the above. Correct answer is option A, such itself is a immovable property. Question number 457. The doctrine of a clause on the equity of redemption is a rule of justice, equity and good conscience. This was reaffirmed by the Supreme Court in Murari Lal versus Devkaran, AIR 1965. Question number 458. A condition converting a mortgage into a sale is invalid as a clause on the equity of redemption. This was affirmed in the case of Gangadhar versus Shankarlal, AIR 1958. This is the correct answer. Question number 459. When a mortgage acquires a portion of equity of redemption, the mortgage is not extinguished completely. There can be only a pro tanto extinguishment of the mortgage right to the extent of the mortgagee acquiring the mortgage's interest. And so far as the other sharer of the equity of redemption is concerned, the mortgage will subsist. This was held in the case of Satyapal versus Rakaiya by AIR 1993, Madhunan versus Madhav AIR 1994. Here correct answer is Madhav versus Madhav, AIR 1994. Question number 460. Section 60B recognizes the right of the mortgagor to inspection and copies of deeds of title relating to the mortgage property which are in the custody of the mortgage. This statement is true. Question number 461. The law will not allow the mortgagor to discharge a debt before the prescribed period in a manner not contemplated in a contract. This ruling refers to Section 62 of the Transfer Property Act. Question number 462. Under Section 70 of Transfer Property Act 1882, the natural accessions are additions to the security and becoming incorporated in it are subject to redemption, not to be redeemed, further accession, none of the above. Correct answer is option A, that is redemption. Question number 463. The provisions for the improvements to the mortgage property is dealt in Section 62 of TPA, Section 63 of TPA, Section 63A of TPA, Section 63B of TPA. Correct answer is option C, that is Section 63 of Transfer Property Act 1882. Question number 464. In case of a mortgage lease, if the mortgage obtains a renewal of the lease, the mortgager upon redemption shall not have the benefit of a new lease, shall have the benefit of new lease, shall have benefit of previous lease, none of the above. Here correct answer is option B, that is shall have the benefit of new lease. Question number 465. The provision of renewal of mortgage lease is dealt in, correct answer is Section 64 of the Transfer Property Act. Question number 466. The provisions of the implied contracts by mortgage is dealt in the Section 64 of the Transfer Property Act, Section 65 of the Transfer Property Act, Section 65A of the Transfer Property Act, none of the above. Here correct answer is option B, that is Section 65 of the Transfer Property Act. Question number 467. When a mortgager dies, his heir is liable to pay the public charges, visit government revenue and municipal taxes. This statement is true within the meaning of Section 65 of the Transfer Property Act 1882. This is the correct answer. Question number 468. Within the meaning of Section 65A of Transfer Property Act, mortgagors shall have the power to make lease thereof which shall be binding on the mortgagee. Option A, such power to lease is subject to provision of subsection 2. Such power is wrong. Such power is not provided in the Transfer Property Act, and D, none of the above. Here, correct answer is option A. Such power to lease is subject to the provision of subsection 2. Question number 469. The mortgage's power to lease would be made in the ordinary course of management of the property in accordance with any local law, custom or usage. The statement is correct. Question number 470. If a decree for redemption is made, a suit for foreclosure or sale would be barred, especially as a redemption decree itself provides for sale or foreclosure in default of payment. Option A, statement refers to provision 67 of the Transfer Property Act. Option B, statement refers to provision 68 of the TPA. Option C, statement refers to provision 69 of TPA, and D, none of the above. Correct answer is option A. Statement refers to provision 67 of the Transfer Property Act. Question number 471. Within the means of Section 67 Transfer Property Act, option A, simple mortgage cannot be foreclosed as the real right transferred is a right of sale. This is a correct answer. Question number 472. Section 67 Clause D of Transfer Property Act is the corollary to the last clause of Section 60 and rests on the same principle of the individuality of the mortgage security. The reason has been discussed in option A, Narendra Narayan versus Dwarkalal Mundan, option B, Ram Sahai versus Devi Deen, option C, �N𝐞𝐿 versus Suresh Chandra 1886, and option D, none of the above. Here correct answer is option C, that is �N𝐞𝐿 versus Suresh Chandra 1886. Question number 473. When the mortgagee, or if there are several mortgagees, all the mortgagees acquire by purchase of or inheritance or otherwise a share of the request pro and to, and they may recover the balance of the debt against the residue of the property. This was decided in the case of option A, Arunachalam Chetty versus Ramaswamy, option B, Visheshwar Dayal versus Ram Sarup, option C, Narayan Rao versus Mr. Chotebai, and option D, none of the above. Here correct answer is option B, Visheshwar Dayal versus Ram Sarup 1900. Question number 474. A mortgage who holds two or more mortgages executed by the sum mortgager in respect of each of which he has a right to obtain the same kind of decree. The liability propounded in, correct answer is option C, Section 67 of TPA. Question number 475. Provision of Section 67A shall not apply if the mortgager sues for foreclosure on mortgage and for sale of the another mortgage. If the mortgager is minor, if the mortgager is insane, any suit. Here it has been asked, provision of Section 67A shall not apply. Option A is the correct answer. Question number 476. What is true about Section 68 of TPA? A mortgagee having the right to exercise a power of sale under 69 shall, subject to the provisions of subsection 2, be entitled to appoint a receiver. The statement is correct, is not correct, is ambiguous. Option D, based on the provision of Section 70. Here correct answer is option A. It is, as this statement is correct. Question number 477. Where the mortgage property is a lease and the mortgagor obtains a renewal of lease, then the mortgagee shall not for the purpose of security be entitled to new lease. Option B, the mortgagee shall for the purpose of security be entitled to new lease. And option C, mortgagee shall not be entitled to new lease. And option D, mortgagee shall be entitled to interest. Here correct answer is option B, the mortgagee shall for the purpose of security be entitled to new lease. Question number 478. If the mortgagor has not insured against fire, the mortgagee is authorized to insure and to add the premium to the mortgage debt. This is a provision under option A, section 73 of TPA, section 72, section 71, section 70. Here correct answer is option B, section 72 of the Transfer Property Act 1882. Question number 479. Section 81 of the Transfer Property Act applies for the mortgage of immovable property and not to the hypothecation of option A, immovable property, option B, movable property, option C, hire purchase goods, option D, installment payments. Here correct answer is option B, movable property. Question number 480. The principle of marshalling applies only where there is a common debtor and not to case of more than one debtor mortgaging their separate property jointly for contracting the debt. This principle pertains to, correct answer is option B, section 81 of the Transfer Property Act 1882. Question number 481. Where the property subject to a mortgage belongs to two or more persons having distinct and separate rights to ownership therein, then the different shares in or parts of such property owned by such persons are option A, not liable to contribute ratably to the debt secured by the mortgage, liable to contribute ratably to the debt secured by the mortgage, liable to contribute interest part only, option D, none of the above. Here correct answer is option B, liable to contribute ratably to the debt secured by the mortgage. Question number 482. Where two properties belong to same owner, one property is mortgaged to secure one debt and both properties are mortgaged to secure another debt, and the former debt is paid out of the former property. Each property is liable to contribute ratably to the latter after deducting the amount of former debt from the value of the property out of which it has been paid. Here correct answer is option A only. Question number 483. If the mortgagee buys a share in the equity of the redemption but not a share in the property itself, he has paid a higher price and a liability to discharge that share of mortgage debt is on the mortgagor and not on him. Then option A, he cannot enforce the whole of the mortgage debt against the rest of the property. Option B, he can enforce the whole of the mortgage debt against the rest of the property. Option C, he can enforce only a part of the mortgage debt, and option D, none of the above. Here correct answer is option B, he can enforce the whole of the mortgage debt against the rest of the property. Question number 484. Section 100 of the Transfer Property Act shall not apply to the charge of transferee on the trust property for expenses property incurred in the execution of his trust, and no charge shall be enforced against any property in the hands of a person who such property has been transferred for consideration and without the notice of the charge. Correct answer is option A. Question number 485. In a charge of order of TPA, there is no transfer of an interest in the property, but the creation of the right of payment out of the property is specified, and such it cannot be enforced against a bona fide purchaser for value. This was decided in the case of, correct answer is option C, Chanduram versus Municipal Commissioner, AIR 1951. Question number 486. The High Court may make rules under the TPA, but such rules, option A, prevail over the general terms of the CPC. This is the correct answer. Option A is the correct answer. Question number 487. Quae prior est tempore, proteor est jure means he who is first in time is first in law. Option A is the right answer. Question number 488. The provision of section 106 of the Transfer Property Act was substituted by the TPA Amendment Act 2002. The provision came into force with effect from, correct answer is option A, 31st December 2002. Question number 489. The amendment of the Transfer Property Act 1882 in the year 2002 amended section 100, section 106, section 108, section 110. Here correct answer is option B, that is section 106. Question number 490. A lease of immovable property from year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by an ordinary instrument, by unregistered instrument, by registered instrument, by written instrument. Here correct answer is option C, that is by registered instrument. Question number 491. Within the meaning of section 108 of Transfer Property Act, both the lessor and the lessee possess the rights along with the liabilities. The statement is correct. Question number 492. A lease of immovable property can be determined. Question number 493. Section 112 of the Transfer Property Act provides for the waiver for the forfeiture, but where rent is accepted after the institution of a suit to eject the lessee on the ground of forfeiture, such acceptance is forfeiture, is not forfeiture, is a determination of lease, is a transfer of lease. Here correct answer is option B, that is not forfeiture. Question number 494. A notice under section 111 of the TPA can be waived, option A, by express or implied consent of the person to whom it is given, by implied consent of the person to whom it is given, by express consent of the person to whom it is given, by notice from either party. Correct answer is option A, by express or implied consent of the person to whom it is given. Question number 495. Section 114 of the Transfer Property Act affords protection to the tenant against forfeiture while the tenant enjoys the immunity from eviction for default in the payment of rent. The landlord gets the corresponding benefit of recovery even such areas are not legally recoverable. Such a equitable provision as is engraft shall govern only to such an extent which does not run counter to any specific statutory provision. This was held in. Correct answer is option A. It was held in Shyam Bhagwan Dubey versus Sheikh Nizam AIR 1994. Question number 496. On an exchange of money, which party gives warrants the genuineness of the money given by him? The provision is dealt in. Correct answer is option B, that is section 121 of the Transfer Property Act. Question number 497. In case of immovable property, the transfer must be effected by a registered instrument, signed by or on behalf of the donor and attested by at least 2 witnesses. This is the right answer. Question number 498. In case of gift of movable property, the transfer may be effected either by a registered instrument signed or by delivery, and such delivery may be made in the same way as goods sold may be delivered. Here correct answer is option A. This is a part of the provision under section 123 of the Transfer Property Act 1882. Question number 499. A gift to 2 or more donees of whom one does not accept it is option C, voidable at the option of the donor. Question number 500. Where the gift consists of donor's whole property, the donee is personally liable for all the debts due and liabilities of the donor at the time of the gift to the extent of the property compromised therein. Here correct answer is option A. This is the provision under section 128 of the TPA. Question number 501. This chapter deals with the gift under TPA. Option A applies to Mohammedan gifts also. Option B does not apply to Mohammedan gift, and option C applies to all caste, creed, etc. Option D applies to Parsi gift only. Here correct answer is option B, does not apply to Mohammedan gift. Question number 502. Every notice of transfer of an actionable claim shall be in writing, signed by the transferor or his agent, or in case the transferor refuses to sign, by the transferee or his agent, and shall state the name and address of the transferee. This is the provision under option A, section 130A of TPA, option B, section 130 of TPA, option C, section 131 of TPA, and option D is not relevant under TPA. Here correct answer is option A, section 130A of TPA. Question number 503. The Transfer Property Act defines the phrase attached to earth but gives no definition of immovable property beyond excluding standing similar growing crops and grass. Option A. These are not double excluded because they are only useful as timber, corn and fodder after they are severed from the land. Here A is the correct answer. Question number 504. Improvements to mortgage property is provided in which of the following section of TPA? Here correct answer is option C, section 63A. Question number 505. Doctrine which required that the transferor must deliver the subsequently acquired property to the transferee who acted upon his false representation and did harm to himself by paying money for what he could not get is called option A, rule against unjust enrichment, option B, implied consent, option C, feeding the grant by estoppel, option D, doctrine of substantial compliance. Correct answer is option C, that is feeding the grant by estoppel. Question number 506. A document required to be registered under section 17 clause 1 to A of Registration Act 1908 is not registered, then the documents will have no effect for the purpose of dash of Transfer Property Act 1882. Here correct answer is option B, that is section 53A. Question number 507. Which of the following is not governed by the Transfer Property Act? Onerous gift, mortis causa gift, universal gift, gift to disqualified person. Correct answer is option B. Mortis causa gift is not governed by the Transfer Property Act 1882. Question number 508. Which of the following doctrine finds application in section 41 of the Transfer Property Act 1882? Option A, doctrine of holding out. Option B, doctrine of feeding the grant by estoppel. Option C, doctrine of lis pendens. Option D, doctrine of acquiescence. Correct answer is option A, doctrine of holding out. Question number 509. Under the Transfer Property Act, which one of the following is not correctly matched? Option A, transfer by ostensible owner, section 41, fraudulent transfer, section 53, doctrine of lis pendens, section 52, doctrine of part performance, 53B. This is not correctly matched. This is section 53A. Doctrine of part performance, section 53A. Here in this question it has been asked which of the following is not correctly matched. So option D will be here be the right answer. Question number 510. Under section 104 of the Transfer Property Act 1882, whom the power of making rule is conferred? Option A, state government. Option B, central government. Option C, High Court. And option D, Supreme Court. Correct answer is option C, that is High Court. Question number 511. A notice under section 111 of the TPA can be waived. A, by express or implied consent of the person to whom it is given. Option B, by implied consent to the person to whom it is given. Option B, by express consent of the person to whom it is given. Option D, by notice from either party. Here correct answer is option A, by express or implied consent to the person to whom it is given. Question number 512. The Supreme Court laid down the distinction between rent and premium in option A, Commissioner of Income Tax versus Panbadi Tea Company. Option B, Mangilal versus Sugan Chand. And option C, Associated Hotel of India versus R.N. Kapoor. And option D, none of the above. In question number 512, the correct answer is option A, Commissioner of Income Tax versus Panbadi Tea Company. Question number 513. In the matters of waste by the mortgager in possession of the mortgage property, the mortgager's liability comes into question when option A, he does not prevent the property from being deteriorated. Option B, the waste of property occurred by his omission. Option C, he does not any act which is destructive but the security is sufficient. Option D, he does any act which is destructive but the security is insufficient. Correct answer is option D, he does any act which is destructive but the security is insufficient. Here we will wind up this MCQ session of Transfer Property Act. It is my humble request, please subscribe this video, please like this video and share with your friends. Thank you so much.